I object for the adjournment.
First four.
What is the item?
Serial number 8, my lord.
2014 MFI.
2014, my lord. Next week,
Why?
I'll have it next week. Respond counsel R4, resale out of state, my lord.
There is one more counsel who is the contesting respondent.
Both two involvement of two vehicles, two insurance are there, my lord. Both claim petition is, my lord, fixed liability on the owner on the ground of no DL case.
we'll see.
First April, my
No,
lord.
no, we'll see the file.
Please.
And looking at the adjournments, then we'll think about whether to grant adjournment or not.
And
Yes.
also list number 3, my lord, serial number 16.
It will be called.
Please, please, get that.
Yes.
Serial number 6, my lord. Serial number 6, my lord. Tomorrow, my lord, I will take steps to substitute service for our
Orders.
6, my lord.
Dismissal of the case against R2.
Tomorrow, my lord, I will file a necessary application for substitute service.
Why not today you didn't file?
No, madam, lordship, party has not come today. I will file.
6, finally list this matter tomorrow. If the application is not filed by tomorrow, the MFA stands dismissed without further reference to the court. If the application is filed, list this matter on Tuesday. Yes,
Achha.
Serial number 11.
yes.
Page
I mean, for cross appellant, translation copy is not there. One
Translation copies of what?
is cross appeal,
I understood. Translated copies of what?
and the judgment and decree, both
Judgment itself is in Kannada.
Kannada, both Kannada.
Already in other thing they have filed.
No, madam.
In MFA, they have already filed. So if you don't file in the cross objection, doesn't matter. You can look at it and pass orders. Yes, next.
page 5, 12 and 13. List 2, page number 3, 8 to 11.
Don't call the orders
Serial
matter.
number 11,
Submission.
this serial number 6.
No order matters mentioning. Yes.
I'm appealing for respondent, my lord.
Hmm.
Taking 2 weeks time, my lord.
Why?
The reason is because yesterday itself we have filed the wakalat, my lord. We have to take the instructions from the client, my lord.
23 matter you have filed wakalat yesterday.
Yes, my lords, for respondent, my lords. I mean, he is residing in Kunigal, my
There
lord.
is a stay in their favor.
My lords,
There is a stay in their favor.
no, my lords. No, my lords.
Huh? Let's see when the matter reaches. Yes.
Yes, my lords.
Serial number 15.
Serial
my
number
lord.
10 in list number 2, my lords. The council informed that, my lord, that the matters are going to settle, my lord. They request 1 week time.
It's on the maintainability of the CP.
She is,
2023 matter.
I am
We'll
the,
see on the merits of it. No. Let the matter.
I am the
settle, we are
proxy
not
counsel,
concerned.
my lord. He is regular advocate. He
Huh?
request- I am the proxy counsel. The regular advocate requested me to take time on the ground that the matter is settling before the parties.
No, at 2023 CP listed before the court on maintainability. And if the matter settled, that is not the concern of the court. The main MC is pending there, it will be taken care of. Ask him to come tomorrow, list this matter tomorrow.
Serial number 15, my lord.
Yes,
Page 4, 12 to 21.
Serial number 15, my lord.
Hmm.
Council on record is not in station to some inconvenient. As informed to take it.
who appears for the respondent?
CP. I'm appearing for respondent, my lord.
You have no objection for adjournment.
Adjournment.
I'm ready to hear you today.
The council on record is some personal inconvenience is not in station. That is why I.
List this matter.
Very simple matter, Your Lord.
Or maybe I-
Oh, that's a problem. In CP is also asking adjournments, court is not able to understand. List this matter day after, on Friday. Yes,
Much of it.
Serial number 16, my. Tomorrow, my lord. The connected matter, one CP, one party.
post along with so and so tomorrow.
Yes,
Yes, next.
serial number.
16, 16. The connected matter.
What is?
CP, one party of 25.
Yes, next.
Page 5, 22 to 25.
Not required. No, I said it, this should be list 2, why not list 2? That's what I told you. No, I said list 3 should be list 1, list 2. I told you. Why should they close 1 and 2? It could be 1. Tell her, don't do it. 1 because it has to be done by 4:45, let them do it. But she can't take about 2 and 3 also. Yes, call the list.
My lord, one submission. No, this is my lord, hearing an IA.
Huh?
LR application was filed, notice. But,
Yes, tomorrow.
all right.
List number 3, my lord.
No examination of the final hearing matters.
Lord, connected appeal is pending before the division bench, serial number 36.
But this has to
Final-
go there.
No. The subject to the result of that, Lord, both pertain to the same notification and same village for the same project. That is for enhancement by the claimant. This appeal is also filed with the claimant for enhancement.
Which case?
Serial number 36, my Lord.
What do you say?
Document is that.
Petitioner, sir. Petition.
36.
36.
Pertains to the same notification. The appeals are pending before the division bench. 2 weeks time may be granted. In the meanwhile, we will move the matter before the division bench if the appeals.
This is matter after 2 weeks. He submitted that in respect to similar notification, matters are pending before the division bench. If or after, in the next date of hearing, the matter will be heard.
Please.
Kindly pardon me, Lord. One submission, my Lord. List number 3, serial number 25. Appellant counsel mother is seriously ill. I take her to hospital. Kindly accommodate, my Lord. Other side also.
I appear for the appellant in 25, serial number 25. 25-1 is the claimant's appeal.
Kindly accommodate, short accommodation.
Yes. The request of land counsel, the appellant in MFA 6516 of 2014. Let's this matter next week.
Next
Give-
week,
Basing
please.
on the dates, give a day.
Please, thank you.
Yes. Call the list.
List 1, serial number 1, dictating
Correspondent.
judgment.
My lords, yesterday your lordship had asked me to cross-check if there is any other judgment after Rani. There is one recent judgment wherein which it's passed by High Court of Delhi, wherein which a recent judgment of Supreme Court is discussed. I would pass on this judgment, my lords. I would take your lordship to the relevant portion. The point that arose is at paragraph number 11, my lords. Paragraph number 11, page 5. Paragraph number 11, my lords.
Paragraph 11.
Yes, my lords.
Page number?
Page number 5, my lords. 5, bottom, your lordship would find. 11, my lords. From the top, about 5th line, my lords. Whether insurance company is entitled to right to recover the compensation paid to the claimants arising out of motor vehicular accident from the owner of motor vehicle involved in such accident, whether accident occurs at a place which is beyond the route for which the vehicle has been granted permit under section 66 of the Act. This is a question that arose before the court. Then, my lords, your lordship would find paragraph number 25, page 19, my lords. Paragraph 25. All the provisions of MV Act has been discussed. I would not read that. A reading of the above provision would show that permit is granted in relation to a particular route, area, region. The route, area, region is therefore a prime consideration and an essential condition of a permit. The same is sacrosanct, functional, and fundamental with various provisions of the Act, emphasizing on the same. Driving of the offending vehicle in an area or a route which is not permitted by a permit would therefore amount to driving the motor vehicle without a valid permit and shall be fundamental breach of the conditions of the insurance policy. Then, my lords. Paragraph number 28, my lords. At page 22, my lords. 28, my lords. In Rani and others, the Supreme Court was considering an appeal against the judgment passed by High Court of Karnataka against the award passed by the Learned Motor Accidents Claims Tribunal, which had, while awarding compensation in favor of the claimants, therein made the insurance company jointly and severally liable to pay the compensation to the claimants. The award had been challenged by the insurance company that the liability to pay the compensation could not have been fastened on it as the offending vehicle did not possess a valid permit to operate in the state of Karnataka, and the permit was granted to this for the state of Maharashtra alone. The High Court of Karnataka held that the liability to pay the compensation was only that of the owner of the offending vehicle. The Supreme Court, however, held that the insurance company should first pay the compensation amount to the respective claimants and shall have a liberty to recover the same from the owner of the offending vehicle. And next paragraph, my lords. This is the recent judgment of the Apex Court. Recently, and more explicitly, the Supreme Court in Gawar Mahmood versus Uttar Pradesh State Road Transport Corporation and others has held that even assuming that there was a valid and effective permit to ply the offending vehicle, the same was not valid for the place where the accident took place. Therefore, the liability to pay the compensation is to be that of the owner of the offending vehicle. I may quote from the judgment as under. Having heard the learned counsel for the parties and the perusal of the material available on record, it clearly reveals that on the date of accident, the appellant did not have a valid and effective permit to ply the offending vehicle on the route where the accident took place. Having extensively gone through the fact-finding exercise, it is categorically recorded by the MACT that the appellant was neither able to prove the original permit, nor was able to prove the information received under the RTI Act. Even the RTI information is considered by which it is not clear as to when disputed permit was issued by him. The alleged permit was issued on so-and-so on Saturday, and no explanation is received as to why the deposit fee was asked on the next day, Sunday. Moreover, assuming that permit was valid as per the date of transport authority, but it is not of any help to the appellant since the vehicle was being plied on a route different than the specified in permit. The appellant has failed to give an explanation to refute the observation made by MACT to ply the vehicle on Roorkere bypass to Haridwar via Meerut, which did not fall within the route of permit issued by the Transport Authority. The said findings of the fact have been affirmed by the High Court and by the impugned order. From the above judgment, it would be apparent that where a person is found driving the vehicle beyond the route or area or region for which the permit has been granted, it would be a case of driving the offending vehicle without a valid permit. Then, paragraph number 37 and 38, my lord, the finding. 37. The lordship got it. Page 31. It is therefore held that non-possession of a valid and effective permit shall entitle an insurance company to seek a right to recover the compensation paid to the claimants from the owner of the offending vehicle. Such a right will also be available to the insurance company where the offending vehicle is being operated at the time of accident at a place for which it does not have a valid permit. In the present case, offending vehicle had a valid permit plying only in the state of Uttar Pradesh. There was no permit for the offending vehicle to be driven in Delhi, where the accident took place. This would therefore be a case of offending vehicle being driven without a valid permit at the time of the accident. The learned tribunal has therefore rightly granted a right to the respondent number 2 herein to recover the compensation amount paid to the claimants, that is the respondent number 2 to 5 from the appellant. This is the finding, my lords. And there is one more judgment by our High Court, my lords. It's an appeal filed by the owner of the vehicle, my lord. This is an appeal filed by the owner of the vehicle.
Yes. What is this judgment?
This is by our own High Court, my lords. The relevant portion is at para 10, my lords. Internal page 6 of the judgment, my lords. Para 10. May I read, my lords?
Same, the judgment is.
Yes, yes, my lords. And the finding is at para 12, my lords, wherein which it is said that it amounts to infraction of policy terms and conditions, and an order of pay and recovery has been passed, my lords.
I'm only on the point whether it amounts to fundamental breach of the contract.
That's what has been said, my lords, in paragraph
As far
number.
as all the courts have discussed about the judgment of the apex court in Rani's case, where there is no discussion at all. It just, the penultimate paragraph.
No, my lords, in
Rani's case.
Gawar Mohammed judgment, that is after Rani's judgment, that paragraph is also, your lordship had just found that it's been extracted in Delhi High Court's judgment. There they have said it in a specific terms.
Generally, what submission you're making appears to be appealing. But somewhere like while dealing with the cases, I had an occasion to say about that, yes, Mr. Krishnaswamy.
In fact, sir was amicus curiae in that Gawar Mohammed's case before Apex Court.
No, that whether they are having a permit, but not having permit to apply at a particular place where the accident has happened, whether it amounts to fundamental breach of the terms and conditions of the policy.
Lord, I have to understand the difference between breach and fundamental breach. Breach is a breach.
But unfortunately, you have to understand it the way how the courts are dealing with it. So, is there any judgment which says that that's not a fundamental breach?
I did just bench of Kerala High Court, subsequent to Middle High School judgment of Apex Court, they considered and they have passed a judgment that it amounts to fundamental breach. Even deviation of a route also amounts to fundamental breach. That is what.
Somewhat, I don't know, like whether like it's somewhere, but I was thinking that I saw a judgment. Like I was of the impression that it's a fundamental breach. Somebody has placed a judgment of somewhere. They said that they are having a permit, but the accident has that day it was spying at a place where where the permit was not granted. So for that, like why the insurance company should be absolved of the liability was the question, if I remember. That's why I asked her. She placed no. When you look at the Rani's judgment, no discussion about fundamental breach and all.
It is a judgment of the Supreme Court.
No. I'm not saying that will not follow.
Blindly.
No, but there is no discussion in that. No, that's why I'm saying, is there any other judgment of the Supreme Court where there's the discussion?
There is little discussion in Gawar Mohammed's case.
And even in Ellava's case also it's there.
Ellava's case was not at all in respect of.
No, but in
That was not the question that was.
also when a vehicle had a permit to ply within a particular area or on a route, it is referring to Rani's case. So it is a fundamental breach.
These are fundamental.
Please come.
Ultimately, pay and recovery, pay and forget.
But that's only on that point.
That would be
The already she has taken only this paragraph with regard to the liability. The finding on record shows that the accident had taken place in a route where they were not having the permit to ply the vehicle. Land counsel for the insurance company had relied on the judgment of the apex court in Amritpal Singh and another versus Tata AG General Insurance Company Limited and others, and also Rani and others versus Nation Insurance Company Limited, and another judgment of the Delhi High Court in case of Gurmeet Singh versus the New India Assurance Company Limited and others, where the learned judge had referred to all the judgments and also the recent judgment of the Supreme Court in Kohar Mohammed versus Uttar Pradesh State Road Transport Corporation and others reported in 2023 4 SCC 381. And also she relied on another judgment of this court, the coordinate bench of this court in MFA number 25416 of 2012 in case of Somnath and Shernappa and others, dated 6th March 2023. Relying on these judgments, Land Council submits that it is a fundamental breach of the terms and conditions of the policy, and the insurance company is entitled for for in all those judgments. The apex court has held that the insurance company is entitled to record the same from the owner of the vehicle in view of the same. As far as the liability of the auto,
25%.
25%, that's a liability of the auto is concerned, the insurance company shall pay and recover from the owner of the vehicle.
Yes, ma'am. Much appreciated. Grateful, madam.
Yes.
Third matter, serial number 2, AM Venkatesh.
In this case, he files a claim petition under MEC, Motor Vehicles Act. That is dismissed. Afterwards, he files a claim petition under WC Act.
The
167 is a bar matter.
the agreed by the orders passed in WCA 28 of 2009, dated 8/1/2013. The insurance company is before this court. It is submitted that for the accident that had taken place on 2/5/2009, initially the claimant had filed MAC number 728 of 2010 on the file of the Principal District and Session Judge, Mysore. And the said MBC came to be dismissed for non-prosecution on 30/8/2011. Thereafter, the present WCA is filed. Land counsel appearing for the insurance company submits that by having initiated the having filed an MBC, having filed the proceedings, initiated the proceeding under section 166 of the Motor Vehicles Act. The claimant cannot file another application, another petition under the Workman Compensation Act in view of the bar under section
167.
Under section 167 of the Motor Vehicles Act. The tribunal, even in the cross-examination also, it is elicited that such an application is filed, and the court, without considering all these aspects, had had considered and passed had granted compensation. When this matter came up, When this matter came up on 25/3/2025, this court had heard the land counsel for the appellant in part, as there was no representation on behalf of the respondent for giving an opportunity for the respondent. This matter is listed today under the caption Part Third. Today also, there is no representation on behalf of the claimant. However, this appeal is of the year 2013, and this court is inclined to pass orders on the merits of the matter. Next para. Having heard the land counsel for the insurance company, peruse the material on record. When once an application is filed seeking compensation for the accident that occurred on so-and-so date, and when the same was dismissed for default, the course available to the claimant is to initiate appropriate proceedings to set aside to get the order set aside.
Restored.
Set aside and to restore the said MVC. But no such application is filed, but in turn, he has initiated the proceedings under the Workman Compensation Act. And these things were brought to the notice of the court automatically obtained the petition in view of the power under section 160, in that view of the matter. The order impugned dated so-and-so is set aside. And the appeal of the insurance company is allowed, and the amount in deposit shall be transferred to the court. The insurance company is at liberty to withdraw the same.
Whether it is transferred or it is, I am permitted to withdraw here.
If you want, you will give the permission, or transfer, withdraw there.
Transfer.
Yes.
Serial number 3, Pradeep.
Therefore, please. It's a parted matter. It's a parted matter. Last week, your lordship has heard the matter.
What are the facts?
That in this case, Manad, our contention as per the FIR, the deceased was proceeding in a mudguard of the tractor, which is not covered under the policy. Nobody is authorized to travel in tractor. Manad,
Is this a case that where the charge sheet is filed?
please, Manad.
That he is not traveling on the mud?
Yes, as per the FIR, Malad, he was traveling in a mudguard of the tractor. But after the investigation, the police have filed a charge sheet against the driver where they said he was traveling in a trailer. Malad,
And what is the evidence adduced by the insurance company to prove contrary to what has been stated in the charge sheet?
For that, Malad, the insurance company, except examining the company officer, no document were placed.
Then why should we look at?
In one of the apex court judgment in Premlata Shukla, where they say that the contents of the FIR are to be looked into
They didn't say
entirely.
No. Did they say that only the contents of the FIR should be looked into, but not the charge sheet?
No, should have been looked into.
No. That is in a case where there is only the FIR before the court.
No,
There is
in
a case.
this case also charge sheet was there, Malad.
No, then what is the sanctity of the FIR?
Not what the observation in this case, Malad, is,
Pass on.
please. Court cannot ignore the portion of the document, contents of the document.
Half of the
Court has to-
document you can't
please,
read it.
That's what, here is the case, Malad, the complaint was lodged, where the, basing on that, Malad, the FIR was came to be lodged, stating that he was traveling in a mudguard. After some time, Malad, without any further complaint.
That's what I said. No, the first document, FIR is a document.
Please.
It need not contain all the details. It is not an encyclopedia. FIR is not an encyclopedia.
Please.
Police, after conducting an investigation, filed a charge sheet. Now, once the charge sheet is filed by the police, now whatever, whether the relevancy and other things, the court will look into. Now, if it is your case that he is traveling on the mudguard, and instead of relying, because there is a charge sheet after investigation, so why should the court look at the FIR unless and until there is some other material to show that, yes.
May I submit? There is an FIR. In order to overcome that FIR, there is no document before the court by the investigating officer why he has come to
Charge
that
sheet is a
conclusion.
document.
That's, there is no document for, there is no further complaint, nor any other witnesses to that. Your lordship. That is the last time also your lordship.
That can't be, that can't.
Please,
that's-
the
yes.
other question, my lord, if he is traveling as an employee of the vehicle, the income taken by the code below is 9,000. That has to.
That come to that. Where is that discussion?
Please.
Where is that?
Para 12 of the, that 1/3 of the deceased income, 9th.
So first of all, what about the income? 9,000 is
9,000.
correct?
No, it should be 8,000.
Yes. Who appears to the claimant?
But
What is the amount as per the table, minimum wages as of the table?
9,500.
it has to be taken in under the ECA Act, not under.
That's what, under the EC Act I'm saying. What is as per the notification, what is the amount?
It is 8,000.
It was,
It's 8,000.
Correct.
So 8,000. 1/3 of it is?
No, 50% has to be taken.
bet you.
Under the EC Act, my lord.
Hmm.
Relevant factor, multiplier. There is no question of granting under the multiplier method. Factor. Schedule is there, my lord. Under the EC Act, there is a
No,
schedule.
no, that next factor, first the amount, 1/3 need not be deducted.
No, 50% of that his salary has to be taken into relevant
Get that,
factor.
yesterday, in some other case also it was done.
No.
Give the act,
Schedule is there.
let's see.
Age factor.
No, factor is there.
Howದು?
Factor is
Right.
there.
Under the 4C,
Hmm.
50% of the amount has to be
Let's-
deducted.
What is, where is it?
Please.
Give him.
Fifty percent of the section 4 of the
Before the tribunal, my lord, they deposited the entire amount along with the interest, the petition claimants, my lord, they withdraw the amount, the entire amount. Even as.
They're entitled, they're recover.
4, A, 4(1)(c). 4(1). ఇది కొట్టేయాలి. ಹಳೆ book ಕೊಡಿ madam. ಹಳೆ book. Please.
Take that.
%50 has to be deducted.
I think that is under 163.
Where?
Under 163A.
Please,
Where is that?
not under 160, remember?
I'm saying where is it? No, the calculation which I was telling you is about under 163. Yesterday, in the other
Please,
case.
please.
Where is it? Where a permanent partial disablement.
Please.
In the case of an injury,
50% of the amount has to be.
because it was not specified such a percentage of the something. So, then one cause.
Under the EC Act, my lord, if it is a case of injury, 60% of his salary has to be taken as a.
The case of an injury specified in part 2 of the Schedule 1, such percentage of the compensation which would have been payable in the case of permanent total disablement, being the personal loss of earning capacity caused by that injury. In case of an injury not specified in schedule, such percentage.
41C.
There, C I'm looking at.
Please. D may kindly be simple. For death is concerned, it is a case of death.
It is E.
D.
D.
Next week.
Where temporary disablement by the total or partial results from the injury. Half monthly payment of the sum equivalent to 25% of the monthly wages of the employee to be paid in accordance with the provisions of subsection 2.
Under the EC Act only.
Where temporary disablement by the total or partial results from the injury, a half monthly payment of the sum wages of so and so to be paid. Yes.
The relevant factor applied for the age
8,000,
of.
50% is 4,000.
Please.
Into?
The relevant factor applicable to this case is 207/98.
That is correct.
Please. That is correct. If that is calculated, 8,31,920 will be the.
Eight lakhs?
8,31,920.
920. There are no other heads.
As against the 12,47,880.
They've already, withdrawn it seems.
Withdrawn.
It is. I am requesting this court to direct the petitioner to deposit the excess amount which was withdrawn.
Yes.
Yes, madam. So far as the quantum is concerned, my lord, there is no dispute. 9,000 was taken. It has to be. It has to be, my lord, 8,000 as submitted by the other side. But the factor is, my lord, 207.98. It is also correct. But the entire amount, my lord, they were deposited and without the amount, my lord.
When was the amount withdrawn?
No, it was deposited, my lord, on withdrawn on 2nd November 2018. My lord.
Why the entire amount is permitted to be withdrawn?
Even the FD amount, my lord, 3 years was FD. It was also mature, my lord, it was also withdrawn, my lord, on 16 November 2011. After the because the amount, my lord, interim order was passed by the Sambal court.
Though they prepared the amount withdrawal is subject to result of this appeal.
No.
There is no such order.
No such order.
No such order.
Take the order sheet. It's here.
Interim order.
When is that order?
Interim order, my lord, on
This is a difficulty if entire amount is
25th
withdrawn.
November 2012.
The amount in deposit shall not be disbursed to the respondents.
It was disbursed prior to the interim order. FD also.
That's what melody. Yeah. Even assuming that they have withdrawn 50%
So
of.
you come to the court with a delay.
Maybe.
After 4 years of withdrawal, the
So
amount.
whatever is available, courts available to you, that you take recourse to that.
So that's what the direction I'm seeking.
No, not
He
to-
direct the appellant to.
The direction, there is no
Take
such a
the
prayer.
recovery proceedings.
EP.
Huh?
It is
Take
available.
the recovery, initiate the recovery proceedings. Agreed with the orders passed in ECA 1 of 2017, dated 19 July 2018. Insurance companies before this court. The claim petition is filed seeking compensation under section 10 of the Workman Compensation Act. It is a case that the deceased, Lokesh, was workman within the meaning of the Workmen's Compensation Act. He was working as a loader and unloader in the tractor for the first respondent on salary of 5,000 per day on daily wages. That on 22/4/2016 at about 7:25 p.m., the deceased had been to the said work under the respondent number 1 in the said tractor. The rise of the said tractor has driven the same with a high speed in a rash and negligent manner, due to which it was capsized to the roadside drain. Deceased fell under the said tractor and sustained the injuries and died on the spot. It is the case of the insurance company that in the FIR, it is shown that is traveling on the mudguard of the tractor. When that is the case, insurance company is not liable to pay the compensation. The court, the trial court, the tribunal had negatived the said contention of the insurance company and held that as per the charge sheet, the claim, the deceased was traveling in the trailer as a loader and unloader, and the insurance company is liable to pay the compensation. The court had taken the salary of the claimant deceased at 9,000, and 3,000 is deducted towards his personal expenses, and 6,000 has taken as salary multiplied by the factor 207 of 98, 207.98. Court had granted an amount of rupees 12,47,880. Next one. Land counsel appearing for the appellant insurance company submits that as per the judgment of the apex court in Oriental Insurance Company Limited was Premalata Sukla reported in 2007-13 SCC 476. The court has to look at the that once a part of it of a document, once a part of a document is relied upon by both the parties, the tribunal cannot be said to have committed any illegal. No, that's not the one. Where is the relevant?
That's what the court has to look into the entire whole document, not the portion of the document.
That proposition is different. He relied saying that if a particular document is relied on by both the parties, the court had to look at the entire document, but not the part of it. It is submitted that the court had, without any basis, looking at the FIR, had fixed a liability on the insurance company, and the insurance company is not liable to pay the compensation. It is also submitted that under the provisions of the EC Act, in case of a death, 50% of the salary has to be deducted, and that should be multiplied by the factor. He submits that the accident had taken place on 22/4/2016, and as per the notification, the salary is under the EC Act, the salary is 8,000. He submits that even the compensation that is awarded by the tribunal is on the higher side. Then counsel appearing for the owner of the vehicle, for the owner, not the vehicle, the owner submits that to the employee. The employer submits that that the court had rightly fixed a liability to the insurance company, and there are no grounds to interfere. Land counsel appearing for the claimant submits that already the entire amount is withdrawn by the claimants, and the calculation that is arrived at by the tribunal is basing on the evidence and as per law, and no interference is called for. Next para. Having heard the counsels on either side, produce some material on record. First, coming to the liability, Land counsel for the insurance company submits that FIR states that the claimant, the deceased was traveling on the mudguard. Once he is traveling on the mudguard, the claimant is not, the deceased is not entitled. The insurance company is not liable to pay the compensation. After the FIR is filed, the police have conducted a full-fledged investigation and a charge sheet is filed. And basing on the evidence, as per the charge sheet, the deceased was traveling in the trailer, but not on the mudguard. The contention that the court has to look at the FIR and it cannot discard the said submission of the land counsel for the insurance company has no legs to stand. FIR is not an encyclopedia where all the things need to be stated. It's the first document information given to the police. Thereafter, the police will conduct a full-fledged investigation and will file a charge sheet. And as for the charge sheet, is traveling in the trailer. If any evidence is placed before the court, if the insurance company has adduced any other evidence to show that at the relevant point of time, the deceased was traveling on the mudguard, then the court would have considered, admittedly in this case, except examining the officer of the insurance company, no other evidence is adduced. In that view of the matter, this court finds that the finding of the court fixing the liability on the insurance company is a well-considered one and no interference is called for. Next, coming to the quantum, as rightly observed, as rightly pointed out by the land counsel for the insurance company. As for the notification, the salary in the year at the relevant point of time, as per the notification, is the minimum wages as per the notification is about 8,000 rupees, and 50% has to be deducted, and it comes to 4,000, and the relevant factor is 207.98, and the amount would come to 8,31,920, which the insurance company is liable to pay. It is submitted that already the claimants have withdrawn the amount. It's for the insurance company to initiate appropriate proceedings for recovery of the insurance company is at liberty to initiate appropriate proceedings for recovery of the amounts. Accordingly, the court is passing the following order. The appeal of the insurance company is partly allowed, reducing the compensation from 12,47,880 to 8,31,920, which the insurance company is liable to pay. Number two, insurance company is at liberty to initiate the proceedings, recovery proceedings. The amount in deposit shall be transferred to the. There is no amount in deposit.
Interest, my lord, and not that. Interest portion, and not that.
That is not disturbed. Yes.
Much.
For orders, this serial number 4, Suresh and Latur.
I have today I have filed the translated copies, my lord.
Who appears? You have the translated copy?
Today it is
Afternoon will take.
my lord, not afternoon, my lord. Some mistakes are there in translation also. I could make out. Could it be taken up any other day, tomorrow or day?
Because all 13 we need to finish. Yes, tomorrow at the request of land counsel for the respondent, it is submitted that the translated copy is filed today. Yes, next.
This serial number 5, Shankar Narayan Bhatt.
Avoid service of notice. Oh, when is this notice sent? Look at it. Oh, this year. Post after service of notice. Next.
6, Arjun. 7.
Appellants in this case filed an interlocutory applications. IA number 1 for recalling of the order.
What about notice?
The matter has been dismissed for non-prosecution. On 17/1/2025, I filed my wakalat on 20th Jan 2025. So, office objection has to be complied.
What are you doing without paying the process from 2022? No notice is ordered till now. Give the file.
No, ma'am.
Right from 2022 till 2024, office objections are not complied with.
They're not complied. The part office objection has been complied by earlier advocate. There are two further office objection has been pending. So thereafter, I filed my NOC wakalat on 20th Jan 2025. So and
Then we'll do one thing. This IA number 2 of 25 to condone the delay of 9 days is filed. You have not compared the office objections right from 2022 to 2025. For this period of 2022 to 2025, insurance company is not liable to pay the interest because no notice is served to them till today.
it's because of the fault of the earlier advocate. I don't want to name that.
Whoever it is, we are not concerned. Why should the insurance company pay the interest from 22 to 25? When you just keep quiet without complying with the office objections, without even till no notice is not issued to the insurance company. If it is agreeable to you, we'll recall the order dated 17/1/2025. Is it a case of death or?
It's a case of death, Your Lords. And also the deceased was an agriculturist.
The court can't come to the rescue of a litigant who is not vigilant. Which is insurance company?
A New India insurance company. Sorry, Shriram General Insurance. Shriram General Insurance.
Liability is on whom?
Liability and we are asking from the Shriram General Insurance. And respondent number 1 is the principal, the Sneha English Medium High School functionally is a school van, the owner of that school van. And R2 is a Shriram General Insurance.
Where is Mr. Sivanagowda? You appear for Sriram. No, we'll recall the order and for Sriram General Insurance, please take notice.
Please.
It's a case of death. Insurance company, the liability is on the insurance company.
Dispose.
So not preferred any appeal, we can dispose of.
We can.
Well, list this matter when Tuesday.
Today is only.
Then you have to file.
No, they have given the direction.
They have given.
They will provide
The
ICIC and
IA
the
number
Shriram General
one
Insurance will
minute.
give direction.
IA number 1 of, where is that? Which IA is for recalling?
IA number 1 is
IA 1 of
for recalling of the
2025
order.
is filed to recall the order dated 17/1/2025. On 17/1/2025, an order is passed observing that none appears for the appellants. 1 week time is granted to comply with the office objections, failing which appeal shall stand automatically without further reference to the court. Now the IA is filed to recall the said order. Land counsel submits that he has filed the wakalat recently and it's a case of death. Considering the plight of the claimants, the said order may be recalled. Considering the reasons stated and considering the fact that it's a case of death, the IA number 1 of 25 is allowed by recalling the order dated so and so. Give a memo for dispensing with the notice to, give him a paper, the notice to R2. No, all the office objections are complied with.
There are two.
What are two?
The second set of the petition has been to file like that. The officer.
That is one. And the next one
The
is?
second, the entire appeal has to be restricted to the single case like that. They have filed come with office objections.
Considering the fact that this MC is of the year, MVC is of the year 2018, and the MFA is of the year 2022. This court has this court directs Mr. PC Sivanagowda to take notice on behalf of the second respondent, Sriram General Insurance Company Limited. Memo. A memo is filed by the appellant stating that the the insurance company, the court tribunal had fixed a liability on the insurance company, and the first respondent, the notice to first respondent may be dispensed with. Considering the memo is taken on record and memo to the first respondent is dispensed with at the risk of appellant. We'll take it up in the afternoon. Look
Please.
at it.
Much up.
For admission, serial number 8, Shashidhar R.
Case of death, my lords. Accident
Somebody was
occurred.
asking time in the morning.
Srishaila and H.S. Lingraj is appearing for the two insurance companies, my lord.
Oh, the case is called 2 times. Learned counsel for the appellant is absent. List this matter on 27/11 at request. So, no adjournments are sought from his side, from Mr.
Raj,
Respondent.
my lord.
This is matter. Next week, look at how many matters are there. Take that. Next week. Second, we'll have it on second.
2nd April, please.
Serial number 9, Pradeep B.
This case I,
Yes, who appear for the respondent? What is the
the
case?
pay and recovery are,
What is this?
but, the vehicle involved in the accident is a gas tanker,
Yes?
gas tanker lorry. For that, he is not having a driving license to drive the vehicle. He had a gym, but hazardous good license was not there. Pay and recovery.
The owner is which respondent?
The owner of the vehicle is ninth respondent.
Served, no representation. The insurance company is before this court, questioning the order passed on MSC number 37 of 2010, dated 13th November 2014. It is a case of the claimant that on 27/4/2010 at about 11 a.m., while he was proceeding towards the residence by walking on the left side of the road, the driver of the HP gas tanker lorry drove in a rash and negligent manner, came from Bangalore side and dashed against the claimant. Death or injuries?
Death case.
Huh?
Death case.
And the deceased died in the said accident. Where is the finding with regard to the liability?
But para 16 onwards. Para 16, last page of that mark. Second respondent has seriously considered as per the section 14(2)(a) Motor Vehicle Act to drive a transport vehicle carrying goods.
It is a case of the insurance company that as on the date, the deceased was not, the driver of the tanker was not having the license to drive the gas tanker which is carrying goods of dangerous or hazardous in nature, and they are not liable to pay the compensation. The tribunal observes that a perusal of exhibit R5 to show that what is that he is carrying in that. It's what
gas.
is a perusal of exhibit R5 would show that at the time of accident in question, the driver of the offending gas tanker was having driving license to drive the heavy transport vehicle. Hence, the insurance company is liable to pay the compensation the held that the insurance company is liable to pay the compensation, and the court has observed that there is no cogent evidence on record. Hence, in the light of the law laid down in Swaran Singh's case, the insurance company cannot be absolved from liability. Next, parallel counsel appearing for the insurance company submits that the court had failed to consider the fact that while he is driving a tanker lorry carrying gas, he needs to have the license to drive the heavy vehicle carrying hazardous substances. Then, taken note of the fact, the court ought not to have having taken note of the fact, the court ought to have applied the principle of pay and recover. Next part. Yeah, the respondents R2A and B, R3, R7 and R8 are represented by the advocate. No representation on behalf of the advocate. R9 is the owner of the vehicle. The notice to him is held sufficient by the court. And this court is proceeding to hear the matter on the merits, dispose of the matter on the merits of it. Admittedly, in this case, he is driving a tanker lorry, which is carrying the gas, which is a hazardous substance, and for driving the said vehicle, a special license is required. Admittedly, in this case, he is not having such license to drive that vehicle. In that case, it's a violation of the terms and conditions of the policy. In that view of the matter, this court is of the view that the judgment of the apex court in Swaran Singh's case applies to this case, and in the compensation amount, insurance company shall pay and shall recover from the owner of the vehicle. The amount accordingly allowed, and the amount in deposit shall forthwith transferred to the court. Next.
10. Pradeep B.
Appear for the respondent, my lord. For the claimant, my lord. Some documents are in Kannada, my lord. They are necessary for disposing matter, my lord. I will file translation petition.
What is it a case of, judgment is in English?
Judgment in English.
Both all of you can read and explain.
I will assist.
Case of death or injury?
Injury. The insurance company is challenging the negligence as well as the quantum of compensation. Negligence in the sense when.
Give the detail.
Please.
The fact. What is the claimed compensation?
24,20,000.
20?
24,20,000 is the claimed compensation.
4,20,000.
Court has granted 14,50,000. The date of accident, my lord, 30/11/2009. The accident was, my lord, according to them.
No. Occupation.
Coolie.
According to
driver come, my lord. Owner, my lord. Driver come owner.
Claim is by wife, son and father.
How much is earning?
75,000 is earning.
Earning per month?
Per month, my lord.
Court has taken?
10,000.
Court has taken 10,000.
What is the evidence that is letting?
The exhibit 3.8 and 3.35 are produced, my lord.
What are they?
They are the, my lord, income, my lord, income getting from the I make, my lord, from the dairy, my lord. Mamul, my lord. Mamul, dairy, my lord.
No. What are those documents?
Document is issued by the Mamul Dairy Federation, my lord. They are getting the income from the dairy, my lord.
Have you examined anybody?
Please, my lord. I have examined, my lord. PW2 is examined, my lord. As the manager of the dairy, my lord.
Now first we'll go to the negligence aspect. Which para?
Right, negligence. Issue number 1, my lord.
Please come to that.
It is It is the case of the petitioner that the deceased Yuvraju was the owner cum driver of goods vehicle. Their contention that taken the company from the minimum of the supply rate. Contents from
Contract from man.
Supply of the milk from different milk producer cooperative society. Deceased was supplying milk to driving the goods canter personally. It is their person contention he was driving the goods canter from Mandya towards Madhu slowly, cautiously, 9:30. Mandyawa College at Bangalore, Mandyawa. Raja tea stall side of the Bangalore so lorry bearing number so was parked in the middle of the road by its driver without any kind of signal. So the result of the same, the canter dashed against to the back portion of the parked lorry. On the account of this, Sivaraju sustained grievous injury. He was taken to Mandya District Hospital. In spite of the treatment, he died so and so. But the Mandya to Madhur road is a two-way road. The insured vehicle was parked on the road, the side of the road. He came and hit the lorry.
With the parking
from
lights
the
on
bill.
or not?
That the parking light, we say that parking was on, but there is no reference either in the police document or in the to that
How
effect.
do you substantiate that contention of yours?
But my respectful submission, the vehicle was parked. He was driving the vehicle. He should have he will observe the ongoing vehicle.
The
He have to
parking-
maintain the distance.
It's not a moving vehicle.
Correct.
It is a vehicle which is parked.
That means
to see, it is at 9:30 PM. Unless and until the parking lights are on, how would anybody know that the vehicle is parked?
It is true,
So
ma'am.
there is negligence on the part of you.
I am not saying that I am not negligent. He is also negligent to that extent because without a light, he will not drive the vehicle on the public road. But it is, if the light is on, definitely something will be noticed. It is a big
Yes,
vehicle.
that we will
Therefore,
consider.
contributory negligence has to be taken into consideration.
That is one aspect,
That's-
contributory negligence. Then comes
Please.
to the contribution.
Had he been
I mean,
little to his right, he told you avoided the accident. Had he been little to his right,
Yes.
instead of going to the left side of the extreme left side of
Yes,
the
yes. You are the insurer of?
Insurer of the.
My lord, I mean respondent in his appeal, in the claimant's appeal.
One appeal by the Pradeep.
No, I
Another-
understand that. There are two vehicles, which
Yes,
is the
ma'am.
van that is
Yes,
where
ma'am.
he is
They have not
traveling.
made a party.
The
Because
insurer,
he himself is the owner of the vehicle, therefore, he has not paid the owner of the
so
canter.
it is about the parked vehicle. Both of you are appearing in two different
Yes,
cases
yes, yes.
for the same company.
Same company.
Same
very
company.
different.
He's for the,
Vehicle is different.
Understood. Yes, next. Now come to the compensation. Where is it?
Uh,
And
Para.
before that, we will look at the finding of the court also on negligence.
Yes, ma'am.
it is in India, but,
Huh?
there is nothing on that.
No, we'll see where is it.
Please.
Relevant portion is Malala, 15 almost.
ಇದನ್ನ ಕೇಳ್ತಿದ್ದಾರೆ
14.
reasons.
Reasons.
Odu.
Number 14, Malay. On the contrary, the second respondent insurance company, in order to establish their case, the legal manager of their company examined as RW1, and wherein he has stated with regard to the fracture how the accident in question had taken place because of the negligence on the part of the deceased Shivraj only, but not due to the negligent act the part of the driver of the offending vehicle. He further stated that though insurance vehicle was parked with the signal, but the deceased without observing the same in rash and negligent manner came in his vehicle and hit back the portion of the lorry. So he stated that the accident in question had taken place because of the exclusive negligence on the part of the deceased Shivraj. So on this ground, he placed for dismiss the petition. The learned counsel for the petitioner during the course of his argument by placing his reliance upon the evidence of PW1 and the evidence of PW2, who is none other than the eyewitness to the incident, and upon placing his reliance on the police papers, contained that the oral and documentary evidence adduced and
Come to para 20, that is relevant.
relevant, Madam.
Para 20.
Please, Madam.
In the light of the above rival contention, I have gone through the records. Admittedly, the incident in question has taken place on 3/11/2009 at 9:30 p.m. near Madaya College in front of Roja Tea Stall by the side of the road, side of Bangalore.
Yes,
Mysore
I've
Road.
seen. Next come to the.
Please, madam. 24, madam. The quantum of the compensation has awarded. Finding, madam.
Para number 24.
24, madam.
Yes.
Before that,
Para
madam.
28 may relevant.
Please.
No, to know the, what is this,
Is
supplying
their
milk to the
contention,
Manmur-
observation is in 28 millet.
Para
Therefore,
number
that is
25 is
Like the
important,
milk from
madam.
different producers
not.
Exhibit P3 and P4.
and more, so from the said business is
ಅದು
earning.
ಬಗ್ಗೆನೇ ಅವ್ರು ಹೇಳ್ತಾರೆ. But in the light of the argument canvassed in respect of the counsel of the party, I have gone through the record. Also, decision relied upon learning counsel for the petitioner. Petitioner claimed that the deceased was earning 75,000 rupees as from the avocation as contended by them. Petitioner, in order to substantiate the said aspect, they brought to the evidence of PW3, who is the deputy manager, Manmol Product Dairy, Gejjalagere. Though he has not spoken about earning capacity and the payment made to the deceased as per the document play before the court. Exhibit P14 to Exhibit 28 and Exhibit 35, but during the course of cross-examination, he has admitted that at the time of issuance of Exhibit P11 to 29, he was not present. So also the place his ignorance with the ignorance of the expenditure incurred by the deceased for the purpose of delivering the milk for 1 kilometer. At the time, at this junction, it will be relevant to.
What is this in Kannada?
I will.
31 bottom.
No, he was not. The PW3 was not present, and he is not. Is not aware
that
how the tender was
And
given to
respond.
him and what was the expenses to transport the milk from one place to another place.
No, with that exhibit, what it shows.
I will
is
explain.
He is getting 75,000. The exhibit shows that every month he is getting 75,000 from that, to whom he is supplying the milk. Now the observation of the court is that he will be incurring the expenses that are not forthcoming.
Yes,
That's
not,
what.
please. There is
So
no.
now this Kannada portion is about what the officer of that.
Is that at the time of preparing this document, he was not present.
Who was not present?
That the PW3 is not
That
present.
officer is not present.
And what was the amount for tender to carrying a milk for to the dairy for a kilometer wise he is not aware.
No, anyhow, it is like this. He'll be procuring the milk from different vendors.
Villages, not
Then he has to pay to them.
They
And
have
after
to pay.
all doing it.
Correct.
Wages paid to
If
them.
the tender amount.
I'm saying something in your favor. I'm saying 75,000 cannot be taken as income because he has to pay the amounts from the people from whom he has taken milk. He has to give them
that is
and
not a
all
case,
his
madam.
transport and all other
Madam,
things
he
have
only
to be.
He is not supplying a milk, he is
He's getting the-
transporting a milk, that's all.
Not supplying.
He is not supporting.
Madam.
No, for supplying milk.
Collecting the milk from the different dairy and he will give it to the.
For that they give him
Gijil.
75,000 per month.
According to that, but no document were placed. Bank statement was.
No,
No.
P14, P28, P35, what are there?
That's the reason you lots of next para may kindly listen.
No, what
After
is this
Canada,
P14?
P14 is a tender notification.
P14,
Please,
what?
madam. P28.
As per the tender notification, how much they have to pay?
Not per kilometer, malada, is paid to 2 rupees. Exhibit P35 for a moment, kindly see, malada.
35.
35. There is a Kannada.
Oh, complete Kannada.
Complete Kannada. For a moment, exhibit P35, malada. In that, malada, clearly showing me how this is earning the amount, malada, from day to day, malada. For monthly, malada. In the overall 9 months, malada, he is earning about 5,85,000,
was
malada.
discussing after Canada, malada.
Take that.
They are also not disputed, malada.
On an average,
For 9 months, my lord, that's it.
no, on an average, it is about 38,000 per month.
Lord, 5,85,000. Another exhibit P8, another document is, my lord.
No, 16/3/2009 to 31. Oh, it is 15.
Please, my lord. The monthly has been paid, my lord.
1/4 to 15/4. That is 15 days.
Please, my lord.
16/4 to 34. That is 36 plus 36. Hmm.
Now your lordship kindly see the exhibit P8. That's what discussion, after Kannada version, my lord, there is a further discussion. Your lordship kindly peruse that. So also upon going through the exhibit P35 and exhibit P8, that is the passbook of Mandya District Cooperative Bank, which shows that the amount mentioned in both documents are exactly tallying with each other, not exactly tallying with each other. What they given the document to show that they have paid 38,000 or something, which is not tally with their passbook.
It's a cooperative.
That's what the
society.
court.
Contrary to document produced.
Both document from the bank only, from the cooperative.
In that case, we will remand this matter.
Please.
We will remand this matter and let him have the advantage of, because when the document shows this much, no court by doing any guesswork will unnecessarily.
Instead of remaining, my lord, it may be disposed of taking as income, my lord. All these documents has been considered by the tribunal, my lord. They are also clearly detailed, my lord.
No, the court given a finding that there is discrepancy. There is discrepancy. No, what is the difficulty that those documents can be obtained by you from the, from that society and the.
The society has given the document. That document has been exhibited.
Then the finding of the court is they are not tallying.
The passbook has been produced by the DCC bank, that is amount has not tallied with that. That is the finding. But another account is there.
Please understand, if the matter is remanded, it's for your advantage.
Again taken so much time. That is the problem.
No, that's, it's not for you. Ultimately, it's for your client.
The claimant.
He's getting some amount from, if that 70,000, if you are able to prove.
10,000.
10,000.
If you are able to prove that 75,000, it is a huge amount.
Huge amount. Not only that, for that he has to deduct the expenses incurred.
That all, whatever.
Wages paid to the claimant and fuel charges.
Regarding negligence,
that we will give a finding.
Kindly, I'll argue. Kindly see.
As far as the insurance company's appeal is concerned,
yes,
that will be dismissed. Insurance company's appeal.
No, there is another point. DL, as per the DL, the deceased age was 38 years. The multiplier which is applied by the court below.
That we will leave it open.
As
far as the negligence aspect is concerned,
then
that we will dismiss your appeal.
Correct.
Remaining all other grounds, both of you raise before the court and the court decide. Which MBC is this? Only one?
Only one.
Agreed with the orders passed.
One is by the owner.
No. This number is somewhat
claimant.
CET 04 something is there. Agreed with the orders passed in MBC number 293 of 2010, dated 17 January 2015. Both the insurance company as well as the claimant are before this court. The insurance company's appeal is MFA number 2627 of 2015. And the claimant's appeal is MFA, the claimant has filed a cross objection, that is MFA crop 34 of 2017.
In that case, I appear for the owner. Insurance company.
In the, you appear for?
Respondent number 4, my lord.
Who is respondent number 4?
Owner of the vehicle.
The facts of the case are, the claim petition is filed seeking compensation of an amount of rupees 24,20,000 for the injuries sustained by the claimant in the road accident that took place on 3/11/2009. 3/11 or 13/11? You said 13/11?
3/11/2009. 3/11/2009.
3/11/2009. It is a case of the claimant that he was supplying the milk by driving the goods canter personally. He had a contract from Manmul for supply of milk from different milk producers, cooperative societies, and he was supplying the milk by driving the goods canter personally. It is a case of the claimant that The society has called for a tender. He has participated in the tender and is earning an amount of rupees 75,000 per month. It is a case that while he was driving the vehicle on 3/11/2009 at about 9:30 p.m. near Mandya, Mandya College in front of Rosa Tea Stall by the side of Mysore Bangalore Road. One lorry was parked in the middle of the road without any kind of signal. As a result, the canter dashed against the back portion of the lorry and the claimant had sustained injuries. It's a case of the insurance company that it is because of the negligence on the part of the claimant, the accident has happened, and the driver has switched on the parking lights, and as such, the insurance company is not liable. The other ground that is taken is with regard to the driving license of the claimant. It is their case that the claimant is not having the driving license to drive the vehicle. Even on that count also, insurance company is not liable to pay the compensation. Then coming to the compensation, the court had considered the income at 10,000. The claimant had relied on exhibit P11, P10, P8, P12 and 13, 14 to 27, P28, P31, 32, 33, 34, 35. As per exhibit P30, this is 30? As per exhibit P35, there are details with regard to the payments that are made. Payments are made on for every 15 days. It appears from that, and as per that, the amount is varying from month to month, and the least being 36,697. The tribunal had considered the income at 10,000 on the ground that
Tribunal has taken two from Malada. Exhibit P8 produced by the not tallying with Malada.
paragraph, which paragraph?
Paragraph, page number 33, page number 23, Malada, paragraph 28 in page number 27, Malada.
Paragraph?
28, Malada, paragraph 28 in page number 37, reliant portion, Malada. Also, upon going through the exhibit P35,
the court
and last
had
Malada,
considered 10,000 and for coming to such conclusion, the court observes that upon going through exhibit P35 and P8, that is passbook of Mandya District Cooperative Bank, which shows that the amount mentioned in both the documents are not exactly tallying with each other. And the person who has given evidence as PW3 was not present at the time of issuing exhibit P11 to exhibit P29. And when his evidence showed that he is not the author of the said document, then whatever the oral and documentary evidence adduced and produced by him cannot be accepted. Accordingly, the said evidence was discarded and the court had taken 10,000.
another goal, Malada, he is not paying a tax, Malada. That's
So, is the court says deceased. It's a case of injury.
Case of death.
Case of death. In the earlier paragraphs, not the deceased. The Institute connects aggrieved thereby seeking enhancement. The claimant is before this court. and the insurance company is before this court both on negligence, liability, as well as the quantum. Then counsel appearing for the insurance company submits that the claim, the deceased was at fault, and as there is negligence, the accident had happened. He was not having a valid driving license, and it is submitted that the court had taken quantum. What you say, 10,000 should also not be taken. You're not on that.
We are on that.
The court had taken 10,000 on the higher side.
For contingent, it is a created document because he is not, if
The
the income
court-
is 30,000, then necessarily is an income tax assessee. No document for claim.
Even professional tax is not paid.
The court has the
Professional tax.
the court had
Professional
taken
one.
10,000, which is on the higher side, without there being the relevant material before the court. The court had done the guesswork. Which year is the accident?
2009, my lord.
2009.
Yes.
Without there be on the guesswork. Then counsel appearing for the claimant submits that the when he had participated in the tender process and basing and he being and as per and being a successful bidder when the contract is awarded to him, and as per the contract when he is supplying when he is transporting the milk, and when the evidence clearly shows that that he has been what are the amounts that have been paid to him, the court on the ground that PW3 has stated that he was not present at the time the documents exhibit P36
35.
35 is given to is issued cannot be a ground for the court to discard the evidence placed by the claimants to show that the deceased was earning 75,000 per month. It is submitted that the said finding of the court is contrary to the evidence on record. It is further submitted that the police records clearly shows that the parked vehicle was parked on the road at the night time without the traffic, without switching on the signal lights, the parking lights, which shows the
One submission, my lord. The police record has clearly shows that, my lord, the vehicle was parked in the middle of the road, my lord.
That's what I'm saying. And when the police records also clearly shows that the vehicle is parked on the middle of the road without the signals, without the parking lights. There is a clear negligence on the part of the driver of the parked vehicle, and court had rightly held that there is negligence, and the owner and the insurer of the said vehicle are jointly and severally liable to pay the compensation. And there is no question of contributory negligence on the part of the driver of the vehicle, on the part of the driver of the parked vehicle. And having heard the counsels on either side, there is some material on record. The first contention is with regard to the contributory negligence. All the records, all the material placed on record clearly shows that the vehicle is parked in the middle of the road and without the parking lights. It is a case of the insurance company that the parking lights are on, and the other evidence on record shows that the parking lights were not on. In support of their contention, they have not examined any witness. No evidence is adduced. So in that case, the question of contributory negligence will not arise. And a vehicle that parked on the road at 9:30, it is a pure negligence on the part of the driver of the parked vehicle. And as the same is insured with the insurance company is liable to pay the compensation. The next issue is with regard to the quantum of compensation and about the terms and about the and the other contention raised is about the driving license. Coming to the quantum of compensation, this court had seen, this court had perused the documents, and the petitioner and the deceased was supplying transporting the milk, basing on after initiating the tender process, and he has been paid the amount. In those circumstances, the court had placed reliance on evidence of PW3 more than on the exhibits, and consider the income at 10,000 per month. In that view of the matter, this court deems it appropriate to remand the matter for giving an opportunity to the claimants as well as the insurance company to adduce the further evidence as far as that aspect, and also with regard to the license, that the deceased is not having a valid driving license also, that aspect is also open for the insurance.
For the DL, age is 38 years. Only
And
regarding-
as per
no
the
dispute
driving
regarding-
license, it is stated that his age is 38 years. Anyhow, while considering the compensation, the court can also consider all these aspects, and it is open for both the parties to adduce evidence in respect of the compensation. And as far as the negligence issue is concerned, this court holds that it is because of the negligence on the part of the driver of the parked vehicle, the accident has happened. Accordingly, accordingly the appeal is allowed, and the order impugned, appeal of the insurance company is dismissed, holding that the insurance company is liable to pay the compensation, and there is no negligence on the part of the deceased. Number two, the claimant as well as the insurance company can adduce, all the parties can adduce evidence in support of their case with regard to the compensation, basing on the said evidence that the court shall consider and dispose of within a period of 6 months from the date of receipt of the copy of the order. Without further notice, the party shall appear before the tribunal on 21st of April.
Yes, ma'am. One more submission, madam. 50% amount has been deposited by the insurance company. Maybe permitted to withdraw money. Permitted to withdraw.
Why not? Even if the calculation is made.
I think that can be done, madam.
Be anyhow more than that, not less than it. Huh? No, whatever amount you have deposited, it would not be definitely not more than less than 10.
I think you will get more than what is.
So there won't be any kind of difficulty for you.
As a tribunal also not
Won't
consider,
be.
madam.
Because
Which are
Result of the appeal, to the petition. Otherwise,
the deposited amount,
clear case I have
the
lost something.
yes, the deposited amount, the amount in deposit shall be transmitted to the trial court forthwith. And the said amount, the claimant is at liberty to withdraw, subject to the result of the MVC.
MSC petition.
Yes, ma'am. Much obliged.
Give it to him. The cause list is, call the next case.
Serial number 11,
Kindly pass on that, huh? Pass on.
Password.
12,
Well, some sort of a settlement is.
Serial number 12, my lord, 7561 of 2017. We have filed Wakalat, my lord, on 6/1/2024, my lord, 6 June 2024, my lord. My name is not forthcoming.
In which case?
7561 of 2017, my lord, in 12. There are two cases, my lord, 12, 20.
MFA 7561.
Please, my lord.
You appear for whom?
Respond number 1 to 5, my lord.
Respondent?
1 to 5.
It shows K. Ananda for R1 and
Please, my
R2.
lord, I have filed NOC Wakalat on 6th June 2024, my lord.
Look at it. You have to look at it whether that is put up or not.
Please, my lord, I have gone to the pending also, my lord. I have acknowledgement, my lord.
It is submitted that Mr. So and so, write on a paper and give her. So and so has filed wakalat for R1 to R5.
Please, my lord.
R1 to R5. The registry is directed to verify the name, verify the same, and print the name of the counsel. List this matter next week.
2, 4,
Yes, next.
13,
Respondent, Lordship, this is the wrongly connected matter being posted. 13 is a DD file kept below. It is a
Who
wrong.
appeared for the respondent?
Respondent is appearing for Sham Prasad.
Where is he?
Is another MFA filed by the claimant.
Sham Prasad is
83.
not in station.
Not in station. Post along with the.
83, 80 of 17.
Post
Your
it.
Lordship can disconnect one because DD file it is not unconnected. It is already
8350
connected
is
one.
wrongly
connected.
Where is it? 8350 of 2007 MFA. Then council submits that MFA number 8350 of 2007 is unconnected with this MFA. The registry accordingly the same is dealing lists this matter on
Along with 83, 80 of 2017.
date. Your date. Yes, next.
Date.
24.
Yes, next.
List 2, serial number 1 for orders.
Mr. Harisha N. No representation for dismissal tomorrow.
Lordship, sorry.
Le-
Sham Prasad is out of station up to second week, 14th of 12th.
Why without he coming to the court?
He is told it. That's why.
They have to be there. Some
correct, yes.
representation has to be there. This matter on 17th of April.
Yes, sir.
Yes. Post after service of notice item number 2.
Serial number 3.
Yes.
Two my lord, interim order extend. Interim order is there, kindly extend it.
Interim order, yes. Interim order granted earlier is extended till the next date of hearing. Yes, next
3.
For having served hand summons on respondent counsel appearing before the trial.
Yes, I have filed the acknowledgement, my lords.
When did you file?
Yesterday morning, my lords.
Do that. When is the endorsement? When is the
24th I
endorsement
have.
of the registry? When the matter is listed today, they have to make the endorsement yesterday. Where is the endorsement?
I have served it personally, my lords. Day before yesterday, I have served it.
Post seeking so and so for orders. Acknowledgement for having served the copy. This is on, what is the date? 25/3/2020. When did you file?
Yesterday morning itself, my lords.
Take that.
And hand summons has been served on day before yesterday, my lord. With the sign of the trial court advocate is placed on the hand summons.
You have served.
I have served. I have served. Day before yesterday, I personally have
At
served.
that, the counsel to the petitioner has already served the hand summons on the counsel appearing to the respondents and filed a memo to that effect. Registry is directed to place the same. This is on Friday.
28.
Lord, sir, kindly next week, Monday or Tuesday, my lords. Friday, I can't take it.
Tuesday.
Much.
Yes.
Serial number 4.
Appearing for plaintiff. Hand summons is served on 22 and the PF is also paid.
You should have filed a memo before the drive with the registry.
We have filed memo for on 22nd itself, ma'am.
You have filed it before the registry.
Yes, you know.
Then it will be there in this.
PF is paid today.
No, anyway, you have served the summons on the respondent counsel.
Yes, Your Honor.
As per the order passed by this court, dated 5/3/2025, the petitioner had taken out hand summons on the counsel appearing for the respondent before the trial court and filed the filed a memo to that effect. What is the name of the advocate?
Sonnegowda, Ningegowda, Your Honor.
Huh?
Sanna Ningegowda. Opposite advocate, my lord.
That's what, to whom you have served the hand summons.
CM Gururaj.
You have served the hand summons on the counsel appearing for the respondent before the trial court. That is Mr. 1 CM Gururaj, and a memo is filed to that effect that it is served on 10/3/2025. The registry is directed to print the name of Mr. CM Gururaj. Is this matter on Friday?
My lord, interim order may be extended.
Interim order extended till Friday.
Much obliged.
Yes, 5.
5,
There for the petitioner, my lord. And summons is served, my lord. On 17/3/2025.
As per the order passed by this court, the petitioner served the hand summons on the counsel appearing before the trial court and filed a memo to that effect. It is served as per the same. It has been served on Mr. T. Girish on 17/3/2025 by way of hand delivery. And that memo is filed before the court. Where do you get that? Where is the signature?
On the back page.
Huh?
On the end of the.
Let's print his name. List this matter also on Friday.
Interim order.
Interim order all are granted is extended till then.
Obliged.
hearing on IA, serial number 6.
No representation for dismissal tomorrow.
7,
I appeal for the appellant, my lord. This case, second appeal, my lord, land acquisition, second appeal. Your lordship was pleased to remand similar matters, my lord.
Who is the beneficiary in this?
Beneficiary in this case
Kaveri.
also, my lord,
Kaveri
Kaveri Niravari Nigam.
Where is the advocate?
I have filed an application that is put up, my lords.
No, that I understand. That, what is his name? Prashant.
Prashant Bhimaya. Prashant Bhimaya.
Prashant B. Afternoon.
Please.
Yes.
petition, serial number 8.
Milord, file the CP
Hmm.
for transfer of RA 85 of 2016, presently pending on the file of the learned district judge Davanagere, over to this honorable
I
court.
think this order sheet is more than the file.
And
Order sheet is, I think the file is smaller than this. Right from 2018. 2000 from 18 it is stayed.
it is stayed, and two appeals are pending before this honorable court, my lord. RFA gulu. Same parties, properties are same, and 3 suits were filed. 2 suits, one suit by the,
Please come to your prayer.
please, my lord. It is, I think, page 7. In page 7.
Withdraw
Wherefore the
RA number 85 of 2016.
pending on the file of the land additional district judge Davanagere and dispose of the same on merits along with RFA 1413 of 2016 and RFA 1841 of 2000 pending before this honorable court in the interest of justice.
Hmm. What is this in respect of RA 85 of 2016?
Yes.
Suit
This
filed by whom?
Suit filed by the petitioner.
You are the plaintiff.
That's right. I am the plaintiff.
You are the plaintiff. What
Yes.
is the suit for?
Suit for bare injunction
Hmm.
against the respondents
Hmm.
in respect of the suit schedule properties.
Hmm. That is dismissed or decreed?
The suit was dismissed.
You filed an appeal, RA number 85.
That suit along with two other suits filed by the petitioner and the respondents were clubbed together, my lord, and a common evidence was recorded, and thereafter all the three suits were
1
dismissed.
minute. Yours is OS number
Yes, my 10 bar 2009.
is your suit
This is my suit.
for bare
Which,
injunction.
no, this is for declaration, my lord.
That's why let's not
Yes.
club both the things and get confused.
I'll come to this. This,
With regard to the bare injunction suit and the appeal I am referring to.
Please.
Not with regard to the other RFS, we will see.
Yes.
So,
This-
your suit is only suit. He has not filed any suit.
he has filed another suit.
Injunction I am talking about. Injunction is independently dealt with.
Injunction suit filed by the petitioner
Uh,
before the trial court.
uh.
Simultaneously, one more suit was filed by the petitioner in OS 10 bar 2009 for declaration of title and injunction against the respondents in respect of the same properties.
When you ask for declaration, you will also ask for consequential injunction.
That should have been done, but instead of filing separate suit, they should have asked for consequential injunction in this.
And how a simple suit for declaration without any consequential relief?
That's how it has been.
Uh,
And my lord, OS number 135 of 2007 was filed by the respondents.
No, 1 minute. No, this 10 of 2009 is suit for declaration.
No, 10 bar 10 of 2009 is a suit for bare injunction.
Injunction.
Yes, my lord.
What is the number of this injunction suit?
Injunction suit is OS 10 bar 2009.
Declaration?
Declaration suit OS 41 of 2009.
Hmm.
And OS 135 of 2007 filed by the respondents against the petitioner.
Hmm. For?
He also sought for declaration of title and possession there.
Declaration and possession.
Possession.
Hmm.
All the three suits were clubbed together, my lord. Common
This is-
evidence was
1
recorded.
minute. Three suits is 10, 41 and 35.
Please.
10, 41 and 35.
Yes, please.
Uh,
And these three suits were clubbed together,
uh,
and common evidence was recorded. Since the parties in all the three suits are one and the same, plaintiff and defendants, and the properties are all, my lord, the same properties. And common evidence was recorded by the trial court. And all the three suits, that's the suit filed by me for temporary or permanent injunction, for
Understood. Declaration
all
is
the, yes,
declaration.
dismissed. Against that, my lord,
And now his suit for declaration, his suit is also dismissed.
is also dismissed.
So all the suits are dismissed.
All the suits are dismissed.
What is the date of judgment and decree?
Oh, yes.
Rajendra sir? Rajendra, yes.
Where are the, sir, somebody is sitting in the court every day. Ask to come.
That is S.V. Patil's colleague, madam. S.V. Patil's colleague. No,
S.V. Prakash.
S.V. Prakash, sir. Prakash colleague.
Nobody is there in the court. Every day they're sitting. They should be, and when they've installed something new, they should be there in the court. Password will dispose of this matter today.
Please.
Serial number 9, Bhargav Ji.
Shall I come at 2:30, please, madam?
My lords, appearing for respondent, my lords, seeks 2 weeks' time, my lords. The reason behind is we have filed wakalat yesterday itself, and we'll take the instruction and we'll file the objections, my lords. Yes, my lords.
Bhargav Ji. Where is the counsel for the petitioner? No representation for the petitioner. Is this matter for dismissal tomorrow? Yes.
Then adjourn. Serial number 11.
Yes.
That wife petition, mother, seeking transfer of MC petition filed by the husband before the Hiriur court to Davangere family court, mother.
Where to where?
That Hiriur to family court at Davangere, mother.
Distance?
Distance is 100 kilometer, mother, more than 100 kilometer, mother. And she had 2 kids, mother. Aged about 5 years and 2 years, mother. That husband has filed the.
What is the stage of the MC proceedings?
That appeared, mother.
Stage.
Statement of objection, mother.
Stay, when is the stay granted?
Stay is granted 20 December 2023, mother.
Yes, please come. The present petition is filed seeking transfer of MC number 50 of 2023 pending on the file of the civil judge within bracket senior division and JMFC at Hiriur to the judge to the family court at Davangere. The facts of the case are the marriage was televised on 30/12/2015. In the wedlock, they are blessed with 2 children who are aged 5 and 2 years. In view of the differences between the parties, the husband has filed MC number 50 of 2023 seeking restitution of conjugal rights before the family court at Hiriur on 13/7/2023. The wife had filed criminal miscellaneous number 438 of 2022 seeking maintenance before the family court at Davangere. It is stated that she is staying along with her parents.
Parents, ma'am.
Along with her parents, and she has to take care of the staying along with the parents, and she has to take care of the 2 children who are 5 and 2 years. The distance between both the places is about 100 kilometers, and it's difficult for the wife to travel all the way on each date of hearing. Though notice is served, no wakalat is filed on behalf of the respondent. Considering the having heard the land counsel for the petition, there is a material on record. Considering the fact that the distance between both the places is about 100 kilometers, and she has to take care of 2 children. Hence, this court is allowing this petition. So and so is withdrawn and transferred to so and so. The wife shall cooperate with the wife shall cooperate with the trial and shall not ask for unnecessary adjournment. Next.
Please, ma'am.
12, Rajat HV.
We request for another 10 days, my lord. I think it would be settled is what my sufficient.
There's no settlement process is ongoing through my lords.
That's what yesterday I got the information.
No, if the settlement goes on, let it go on before the trial court. It's a 2024 CP. Why should we
Yes,
keep
my
it
lords may
pending?
give me 10 days, my lord, or on Monday at least.
Monday. Let's
Tuesday.
start on Tuesday. Yes, no further adjournments.
Please.
Interim
Next.
order.
13,
Interim order.
Sridhar CS.
Intermod order granted is extended till then. Yes, 13.
Milord,
From where to where?
Monday to Bangalore, Milord. And
Distance?
Bangalore, Milord. He is also working in bank. Distance 100 kilometers.
100 kilometers.
Please.
He's also working in Bangalore.
Oh. And I also got a son also, and I've filed criminal miscellaneous in Bangalore. That is also pending.
Hmm. According to you, he's residing in Bangalore and filed a case in Mandya.
Please, Milord.
The present petition is filed seeking transfer of MC number 275/2023 pending on the file of the principal senior judge, the CJM at Mandya to the family court at Bangalore. We submitted that the marriage has taken place on 8/7/2018 at Bangalore, and in the wedlock they're blessed with a child. The husband had filed a MC 275 of 2023 seeking restitution of conjugal rights, and the wife on 25/4/2024 had filed criminal miscellaneous at Bangalore.
Please, Milord.
Miscellaneous on
Family
86 of 2024 on the file of
family court principal is, I'll just see the order sheet.
Principal Judge Family Court at Bangalore, my lord.
Additional order bರ್ತದೆ.
Page number 29, my lord.
You're supposed to say where you have filed criminal miscellaneous on the file of the principal judge family court Bangalore. And it is submitted that the husband is working in Bangalore and to harass the wife who is staying in Bangalore, he had filed a case at Mandya. Next para, though notice is served on the respondents, no wakalat is filed on his behalf. Considering the argument of the land council, considering the submission of the land council, and the fact that the husband is also staying along with the is working in Bangalore, and the distance between Mandya and Bangalore is about 150
199
kilometers, 100 kilometers. This court deems it appropriate to allow this petition, and with so and so, so and so.
14, grateful. 14, Pradeep, please.
Petition. Respondent filed a divorce petition at Krishnagara. Petitioner is residing in Channapatnam. She also filed a MC petition, the maintenance petition in Channapatna. It's pending for consideration. It's nearly 300 kilometers, my lord. A small kid is there, my lord, 4 years old. The petitioner residing with her parents.
Or to withdraw divorce petition pending on the file of the Post Nagar Shimoga.
Please.
Transfer to the principal at Channapatna. Distance is?
300 kilometers.
See, the petition is for seeking transfer of MC number 23 of 2023 pending on the file of the senior judge in JMFC, Post Nagar Shimoga, and to transfer the same to the principal senior civil judge at Channapatna. It is stated that the distance between both the places is about 300 kilometers, and the marriage has taken place on 8/12/2019, and in view of the disputes between the parties, she is staying where? At Channapatna, along with the parents, and this MC is for no chronology of events, sir.
Sir. Criminal miss, my lord, so OS number.
Criminal case, sir. What is this MC? MC for divorce.
Yes, my lord.
Yes, filed MC for divorce.
So 23 of 2020.
No dates, nothing.
Filed on 13/6/2023, my lord.
And the wife had filed criminal miscellaneous seeking maintenance on the file of the family court at Channapatna. They submitted that the distance between Shimoga and Channapatna is over 350 kilometers. And in the wedlock, they're blessed with a child, and the wife has to take care of them. Next para, considering the submission of the land council. Though notice is served, there is no representation on behalf, no wakalat is filed, considering the reasons stated, and considering the argument of the land council, and considering the distance is 350 kilometers, which has to take care of the child and is difficult for her. Accordingly, petition is allowed. Since she shall cooperate with the trial. Next.
15, 16 adjourned. 17,
Petitioner, my lord. Petitioner is a wife seeking transfer from Chenpatna to Bangalore. And she is staying with her mother in Bangalore, my lord. Her mother is also old aged, a widow lady.
Of which year?
MC is 24, my lord.
2024.
What do you say?
My lordship, I have filed my objection yesterday to the main petition and also served the copy to the opposite party.
What is your objection?
My lordship, the objection says that the petition has,
Use the mic.
the petitioner, the petitioner has, apology, my lordship. The petitioner has filed a transfer petition to the Bangalore from Chenpatna, but my lordship, she has mentioned the petition by saying that she is unemployed. But according to the source which we got to know that it is very clear that she is employed now. She is working as a children caretaker.
Where?
She is earning in Bangalore, my lordship. She is earning 22,000 per month. But they have not produced any documents before that. They have hidden that from the petition.
No, let us assume that she is working. Then
Yes, my lordship. Yes, and my lordship, the petition respondent is a public servant. He is working in Chenpatna Gram Panchayat as a water service department. So, no, my lordship, if the petition is transferred to the Bangalore, he has to come to Bangalore regularly. And more than that, my lordship, recently last week, the respondent has gone under the eye surgery. So now he is under the bedridden, like 3 months of bed rest is required, my lordship. The required documents I have produced along with the objection.
So in that case, you can ask the trial court to give you a date after 3 months. That can't be a reason.
But my lordship, my party's salary is 15,000 per month. She is earning 22,000 per month, my lordship. My party has to take care of his parents also. His parents are elder parents. They have a medical expense of 3,000 per month.
They
my
don't
lordship.
have children?
No, he's the only son, my lordship. And they have sister which is married. He's the only person who is taking care of his parents, my lordship. She is earning, she is taking care of her mother, but apart from this, she has no responsibility. But respondent has a responsibility of
Or
his
you
parents.
want traveling expenses whenever you come to Bangalore?
Pardon, my lordship?
You want traveling expenses whenever you come to Bangalore?
It's not only about the traveling expenses, my lordship. It will cause inconvenience to respondent.
It
to
also cause
regular.
inconvenience to her.
It will cause, my lordship. He has to come to Bangalore regularly. So
Is it the fact that you are earning 22,500?
No, my lord, no, my lord. It's
What
false.
is the evidence you have placed before
my
the-
lordship, right now we don't have any evidence. We recently got to know about that, but we will file the evidence in the trial court, my lordship.
The present petition is filed. Seeking transfer of MC number 8 of 2024.
My lordship, I am producing the citations too, which is in our favor, my lordship.
I take that pending on the file of the senior civil judge in JMFC at Channapatna, Ramnagar district, and transfer the same to the civil judge and JMFC. Fifth Additional Family Court at Bangalore. The petition is filed by the wife. It is stated that the marriage has taken place on 8/6/2014 at Channapatna. And in view of the differences between the parties, initially on 1/7/2023, wife had filed a maintenance case against the husband, which is pending before the Fifth Additional Family Judge at Bangalore. That's criminal miscellaneous number 529 of 2023. And after service of notice, the husband has appeared and filed objections. And the case is coming up for the hearing on interim maintenance. Thereafter, on 28/2024, the husband has filed the divorce petition. That is MC number 58 of 2024. No children.
No children,
It is submitted that the distance between both the places,
60 kilometers.
60 kilometers, and it's difficult for the wife to travel. It is stated that she's unemployed and she is depending upon her parents. The objections are filed with the respondent husband stating that she is working and earning 22,000 and odd. No document is placed before the court in that regard. It is also submitted that he's working in a public, he's working in
Gram Panchayat.
He's
Waterman.
working in a Gram Panchayat And as he is a public servant, it's difficult for him to travel to Bangalore. He has to take care of his old aged parents. He has undergone the eye surgery for 3 months. He has to take rest. Under these circumstances, he cannot travel. Then she had relied on a judgment of the High Court of Delhi in case of Harpal Singh versus Sonia Singh. And then the court felt that it finds merit in the contention of the counsel that exercise of transferring the case from the district court Karkaduma to district court Rohini may be actuated by requiring the respondent to spend money fresh on account of engaging of a counsel and accordingly dismissed. She has relied on another judgment of the High Court of Kerala at Ernakulam in case of Maria Joseph
Anup S.
and Anup S. and others. Where in the case, originally the permanent resident, originally the petitioner is a permanent resident of Pala and they've been residing in Pala. And the transfer petitions have been filed only on the ground that the petitioner shifted a residence at present to Attingal, that too in a rented house. Hence, shifting a permanent residence to a temporary residence, that too in a rental house by itself is a good ground is not a good ground to transfer the pending cases within the jurisdiction of the permanent residence of both the parties. The rationale is, in the case of temporary residence, particularly rental accommodation, the same is not at all static and it can be changed for any immediate reason. If cases are transferred to such temporary abode, again and again cases will have to be transferred when the temporary residence being shifted. Therefore, availing a temporary residence either by way of rental accommodation or otherwise shall not be a ground to transfer the cases. Relying on these judgments, then counsel submits that the petition, the pending MC at Chandayapatna cannot be transferred to Bangalore and it would cause hardship to the wife. This court, having heard both the counsels, peruse the material on record. Admittedly, the wife is staying in Bangalore along with the parents, and the distance between both the places is about 60 kilometers. The two contentions that are raised is with regard to that the wife is employed and earning more salary. Second is husband is working as a public servant. Third is he is having had an eye issue and he has to take rest for 3 months. And third, another ground is he has to take care of the parents. This court do not find any force in the argument of the land counsel for the respondent. And all these grounds cannot be the reasons for not transferring the case from Channapatna to Bangalore. The judgments that are relied on by the counsel do not apply to the facts and circumstances of this case. With regard to the salary that she is earning or the job she is doing, no material is placed before the court. Just because husband is a public servant, that cannot be a ground not to transfer the case. Considering the fact that she's staying at Bangalore and along with the parents, considering the distance and the fact that even before he filed a MC, wife had filed a criminal miscellaneous 529 of 2023 before the court at Bangalore, that is on 1/7/2023. Husband's MC is 28/2024 and he has to contest the said MC before this court. For that, he has to come to Bangalore. In that view of the matter, this court deems it appropriate to allow this petition. Accordingly, so and so
My lordship,
is withdrawn from so
3
and
months
so.
of exemption of the appearance.
Huh?
3 months of exemption.
That you should ask before the court, not this
My
court.
lordship, if
But
this
he is
court-
yesterday came to Bangalore and shown the affidavit. My lord.
Accordingly, the so and so is withdrawn and the wife shall cooperate with the trial and shall not with the proceedings and shall not ask for unnecessary adjournments. Yes,
18,
Much over.
Srikanth Patil.
yes.
My lord, appearing for petitioner in this case.
Appearing for respondent, kindly pass over, my lordship.
Pass over.
No, my lord, kindly, my lord, I'm proxy counsel. My lord, the advocate for petitioner, my lord, some family emergency, my lord, he had to go out of station.
Tuesday.
Tuesday, my lord. Much
On
obliged.
Tuesday, there is request
Please.
of response for the petitioner. Yes, 19.
19.
Transfer petition.
Respondent husband.
It is the transfer petition, my lord. Husband has filed the divorce petition against the wife, my lord. Before the third edition family court in Bangalore, my lord. My lord, we are
Here?
to 2024, my lord. My lord, we are seeking a transfer on the ground that one small child aged about 21 months
Where?
from Bangalore to Mysore, my lord. Distance is 150 kilometers, my lord. And my lord, one small child is there, aged about 21 months, my lord. And it is very.
But she has done her schooling. She was born here in Bangalore. She done a schooling here in Bangalore. She graduated from here itself. Only for time being, madam, she has gone for along with her father. She has gone to Mysore. That's it.
No, who is at Mysore?
Her father is there in Mysore.
She's residing with him.
As of now, she is residing there.
Not as of now. When you right from the day the both of them are separated, she's staying with them.
Please.
Because she is dependent on them. Please come.
My lord, may kindly note my submission. She was born here in Bangalore.
The present petition is filed to transfer MC number 33330 of 2021. It appears as MC of 2020 or 2024, pending on the file of the third additional principal judge family court at Bangalore to the court of principal judge family court at Mysore. It is submitted that the marriage had taken place on 21/12/2024 at Mysore.
Marriage taken place in Mysore, my lord.
Has taken place at Mysore. The wedlock, they're blessed with the son on 15/5/2023. And in the month of November 22, both the petitioner, the respondent, the petitioner left the matrimonial home. On 5/6/2024, the husband has filed the MC seeking a dissolution of marriage on the file of the family court at Bangalore. Next, it is submitted by the land counsel to the petitioner that now the wife is staying at Mysore along with her father. And the distance between both the places is about 150 kilometers. Now the child is 21 months old and she has to take care of him. As such, the petition may be the MC pending on the file of the family court Bangalore may be withdrawn and transferred to Mysore. Learned counsel appearing for the respondent husband submits that right from all her education.
She was born in Bangalore.
Born in Bangalore, and throughout her education is in Bangalore. Only for the purpose of harassing the petitioner, the present transfer petition is filed. Next paragraph. Having got the counsels on either side, there is a material on record. The admitted facts are that the wife, after the disputes, is staying with the father along with the child who is aged about 21 years. It is the contention that as she had studied in Bangalore and to harass the husband, the present petition is filed. That contention cannot be accepted. As the parents are residing in Mysore and in view of the differences between the parties, when she had started residing at Bangalore, considering the distance of 150 kilometers and that she has to take care of the child who is 21 months old, this court deems it appropriate to allow this petition accordingly. See, withdrawn, transferred, and the wife shall cooperate. Next.
20,
Waiting for the petitioner wife, petition, my lord, seeking
I
transfer
paper
from Bangalore to
respondents
Shimoga, my lord.
to
There is
file
a
objection.
distance
That's it.
about
Statement of
310
objection.
minutes.
Huh?
Statement of objection.
You have given him? Yes, list this matter on Tuesday.
Interim order, my kind list.
What earlier granted is extended till then.
Obliged.
Next.
21,
Wife's petition seeking transfer of the divorce petition filed by the husband at Anekal. Anekal, Bangalore rural. It's 35 kilometers distance,
Anekal to?
Bangalore.
Hmm.
Both are working at Bangalore only. He's permanent resident of Anekal Taluk. For that reason, husband has filed the divorce petition at Anekal. Now, wife also filed a petition for really maintenance, which is pending at 5th Additional Court, Family Court, Bangalore. To attend both court, it's inconvenience. For that reason, the wife has filed the present petition.
Children?
No children. Petition is of the year 24.
Why can't, Anekal is here only.
Yes, but to attend two courts, she has to take leave for.
What two courts?
Wife also filed a petition before family court.
Which year is the MC?
MC 2024. Now it is stood posted for evidence of.
Submitted that the wife had filed a petition for maintenance at the family court in Bangalore and husband had filed the MC.
Yes.
Divorce on the file of the family court at Anekal. It is submitted that she is working and it's difficult for her to travel 35 kilometers and also to attend both the courts. Considering the same, they shall be stay of all further proceedings in MC number. The petition shall take out hand summons on the counsel appearing for the respondent before the trial court and shall file a memo to that effect by 17th. If the memo is filed by 17th, list this matter on 21st, or else the stay granted by this court stands vacated. Next.
22, R. Kiran.
I appear for the respondent in this matter, my lord. My lord, based on the memo the petitioner has filed before the trial court, informing that, my lord, they have filed this petition for transfer, my lords, and I have filed my power. So, my lords, if the petition copy is served to me, my lords, I'll file my objections by next date of here.
Your Lordship, I am seeking transfer of OS suit from Bangalore to Shimoga, my lord. Distance is 300 kilometers. OS suit is filed by the respondent seeking compensation of 1 crore rupees, my lord. On the other hand, my lord, there are two cases pending in Shimoga, my lord. One is the divorce case filed by the respondent, which was transferred from.
If he wants to file his objections, let him file. We can't stop him from filing
Yes, my lord,
objections. The respondent counsel, the respondent seeks a week's time.
Yes.
Week's time for filing objections in this matter on.
Maybe directed to serve me a copy of the
On
petition.
the-
serve it, my
on the
lord, I'll
9th of April, and counsel for the petition should serve the copy of the petition on the council today.
Obliged.
Yes.
53, Sridhar Murthy.
Wife petition seeking transfer of the restitution of conjugal right petition filed by the husband at Maddur. Maddur. It's 90 kilometers away from Bangalore, wherein wife is also.
From Madhu to Bangalore.
Maddur to Bangalore. Wife has also filed a petition seeking dissolution of marriage, just pending
At
before.
Bangalore.
Yeah, at Bangalore. 3rd Additional Court, Bangalore.
Husband filed for restitution. Wife filed for divorce.
Divorce.
Which year is that petition filed by husband?
Husband is 24. Divorce petition is of 24. Dissolution.
It is submitted that the wife had filed the MC seeking divorce on the file of the family court at Bangalore, and husband had filed the MC seeking restitution of conjugal rights at Maddur. And distance between both the places is about
90 kilometers.
90 kilometers. And it's difficult for the wife to travel. Same stay, hand summons, memo, same order like in the other case. Yes. Next.
24, Balakrishna.
I'm for the petitioner in this matter, my lord. Petitioner is seeking transfer of the petition, MC petition 113/2024, which is pending before the 5th Additional Family Court at Bangalore, from Bangalore to Nelamangala Court. And
Bangalore to
Nelamangala Court.
Nelamangala.
Yes, yes. There's a distance 27 kilometers, and the respondent is the resident of Bangalore, and he is a contractor by profession, and he hails from influential political family. And the petitioner is has a kid aged about 4 years, and she has aged
About?
4 years, and aged parents, and her grandmother is bedridden, my lord. And apart from distance and personal inconvenience, and there is a serious threat to life by the respondent. Therefore, the petition is
Any
seeking.
complaint is given in that
No,
regard?
no complaint has been given.
Once a complaint is not given, the threat perception we cannot consider.
Yes. No, it's a inconvenience.
Inconvenience will
Yes,
hear,
yes,
but
yes,
not
madam.
on threat.
Yes, yes.
How much is the distance? 20?
The 27 kilometers from here, Bangalore to
Now,
Nelmangala.
where she stays and how much is the distance to the family court?
No,
in
she
Bangalore?
stays in Nelmangala, and her she has aged parents, and her grandmother is
There is a
bedridden.
family court at Nelmangala.
Yes, yes, ma'am. No, no family court. Senior civil judge,
Hmm.
principal senior civil judge, and JMFC court is there,
Uh,
Nelmangala.
the
That court has got
presentation is
jurisdiction.
Seeking transfer of MC number 113 of 2024 pending on the file of the 5th edition principal judge, family court at Bangalore, to the principal senior civil judge JMFC at Nelmangala. It is submitted, the wife is staying at Nelmangala. And the distance is
27 kilometers.
27 kilometers. She has to take care of the child who is aged 4 years.
4 years in.
4 years. It is submitted that she's staying with the parents, her
Aged parents.
aged parents and the grandparent.
Grandmother is a bedridden.
And the grandmother is a bedridden, considering the submission of the land council, and considering the distance between both the places, they shall be stay of all further proceedings. So and so.
Much
And
obliged.
summons.
Yes, yes,
Date
ma'am.
is, which date is given in the other case? 17/4.
Yes.
Yes.
So 19/4 is the date of hearing before the family court at Bangalore. 19/4.
Then 19/4 is a Saturday.
Yes, 19/4 is the date of
Then
hearing before
by
the trial court.
21, a memo shall be filed. And if the memo is filed, list it on 22, or else the stay granted by this court stands vacated.
24.
Yes, not 20. You said 19.
Yes, 19 is the date of hearing before the trial court. It's
Yes,
posted for
so that's why I said-
evidence.
That's why 20, what evidence, already the trial has started.
No, no, respondent's evidence.
Trial has commenced.
Trial not yet commenced, not yet commenced. Posted for evidence.
The list, you have to file a memo before the court by 21st
Yes, my lord.
of April.
Yes.
22nd, if it is filed, it will be listed on 22nd.
Yes, ma'am.
Or else the stay will be vacated automatically.
Yes, my lord.
Yes.
Much obliged.
Next.
65, Vijay Kumar K.
Appear for the appellant in this matter. Trial court's records may be necessary, my lord, for considering this. The appellants are the defendants. Suit filed.
No, for admission.
It is admission. Once a interim order is granted, notice is served, and other side is also represented.
Yes, let's see. What is this, what is the order of the, who is the plaintiff?
The respondent number 1 is the plaintiff before the trial court. Her case is that she was allotted suit schedule property.
Suit for?
Suit for declaration, possession, and arrears of rent.
Declaration, position and arrears. What happened?
At the first instance, suit was dismissed. The plaintiff went in appeal. In the first appeal, the trial court judgment is set aside, and again the case is remanded back to the trial court for considering afresh and appointment of commissioner and all. My humble submission is the evidence placed already on record is sufficient to decide the case, and no additional evidence. She has not filed any application for additional documents nor sought for any application.
Let's see the finding. Come to the order.
Page number 30, para number 33, observation.
Para number 30.
33 in appeal RA, page number 39 onwards.
Please read.
My humble submission is first the case of the plaintiff is that she has been granted the scheduled property as per exhibit P1. She claims that the government has allotted a constructed house. The trial court comes to a conclusion after perusal of the exhibit P1 that exhibit P1 is in respect of only a site property. And there is no pleading whatsoever. So where the, whether the plaintiff constructed later the house, or it is a case that she was allotted a house by the government herself, and the defendants came in permissive possession, and they agreed to pay the rent for some time, and they did not pay the rent, and she want the claim back the possession. The case of the defendant is that it is their independent property, and that produced 3 sale deeds to show that how the title they derived, and ultimately defendant number 3 is in possession.
Registered documents.
Registered documents. The trial court come to a conclusion that since the plaintiff she has not even produced the layout plan or the revenue documents in respect of the property which she claims, and there was no southern boundary was also not actually described properly. Considering all these facts, the trial court dismissed the suit. Since she had claimed that it is a site, she claimed that she was allotted a house, whereas in the allotment letter itself it is shown as a site. And in the first court, the first appellant court only coming to conclusion that one of the defendant had admitted the allotment made in the favor of the plaintiff is not disputed, and allotment made in favor of the plaintiff is not set aside by any order. And since the defendant claims that they are in possession of their property, there is nothing wrong in remanding the case to the trial court.
Let's see the order. 33, or you want to read some from other paragraph?
The respondent counsel said, may I seek for a pass or my lord, I will continue to.
Pass over.
These 3, serial number 1, final hearing, T. Mohandas Shetty.
For the respondent. Yes, second respondent.
Where is Mr. Mohandas Shetty? He was not there on the last occasion also.
Yesterday also he was not there.
We'll hear it.
There are 5 claim petitions.
Let me just look at it. Where is the... Keep Mr. Umesh always mute. Whenever his case is called, then I think it has not come up before me.
Yesterday it had come.
At what time? Because nothing.
Yesterday it did not reach.
No representation for the appellant. Counsel respondent is present. This matter as part of tomorrow.
Not tomorrow, my lord. I'm not in station. Either first or second, my lord.
Second.
Please.
Serial number 2, Krishna Kishore, yes.
I appear for respond counsel, Mayor. I appear for respond counsel, Mayor. My lord, the first respondent said to have been suffered injuries.
You are on the ground of?
Yeah?
You are on the ground of what? Liability?
Liability.
What is your case?
My lord, the driver of the insured vehicle was not having driving license. Complaint was filed against the driver by the injured himself. He was in the drunken stage at the time of accident, which fact is forthcoming in the charge sheet. The driving license of the charge sheet.
The claimant is traveling on a?
Is a third party. Outside the vehicle, accident occurred. Lorry dashed against him while he was moving on a motorcycle. Insured appeared before the tribunal.
According to you, the driver of the lorry is not having the driving license?
Yes, driving license, and he was under the influence of intoxication as per the charge sheet itself. The owner appeared before the court and filed a statement of objections contending that he was driving the lorry at the time of accident. And he has produced the death certificate of the so-called accused driver and driving license of himself before the tribunal. Kindly come to ink page number 26, please. Second line, minute. When the owner of the vehicle,
1 minute.
ink page number 26, internal page 20, minute. Second line, minute. When the owner of the vehicle alleges that the driver was having license to drive the said class of vehicle, it is for him to prove the same In the case on hand, respondent number 1 has not at all produced the driving license of charge sheeted driver, Mr. Venkatesh. If really the driver was having the driving license, respondent number 1 could have produced the same for perusal. So in such circumstances, in case of production of license of Venkatesh, it has to be inferred that Venkatesh was not having driving license and therefore respondent number 1 has not produced it. The duty is cast on the owner of the lorry, that is respondent number 1, to satisfy himself by going through the driving license to the prospective driver before entrusting the vehicle that he is having valid driving license to drive this at the class of vehicle. If he had seen the unsatisfied Venkatesh was having driving license, what prevented him from producing the same before the court? So under such circumstances, the contention of the respondent insurance company has to be accepted that charge sheeted driver Venkatesh was not having driving license to drive the said class of vehicle. As already discussed above, if it is accepted as contended by respondent number 1 that he was driving the lorry in question, he was not having driving license to drive the said class of vehicle. So looking from any angle, there is breach of terms and conditions and policy regarding the entrustment of the vehicle to the driver who is authorized to drive said class of vehicle.
They say that the owner of the vehicle has to pay.
In the first instance. Subsequently, he filed a review petition before the court by producing his driving license endorsement, owner of the vehicle. The same is accepted by the tribunal. Therefore, I am in question. He has not produced the driving license of Mr. Venkatesh, who was on the wheels at the time of accident.
Where is that?
No?
Where do you get that?
Charge sheet. No.
No. Where is the order in the review?
Review. Order. In page number 39, my lord.
Will it file against the review order or not?
Review order.
Where is the review order?
My lord, in page number 39, my lord. Paragraph number 8. Paragraph number 8. I have carefully gone through the judgment passed by this tribunal in MVC case. Perused the consent of Exhibit R2. It is true that Exhibit R2 is the Xerox notarized copy of smart card. It is convinced by the petitioner to this court that Exhibit R2 did not contain all the endorsements that were found in original driving license. The learned counsel for the petitioner has also produced the extract of DL issued by Regional Transport Officer Chikmagalur. This pertains to owner, along with the endorsement. Both of these documents make it clear that driver of the offending lorry was having license to drive HTV with effect from 30th June to 1998 and from 31.
Lower court record is not there. What is this exhibit?
Yeah.
Exhibit.
That is not marked, my lord. It is part and parcel of the
Look
order.
at it. Show, give it to him. Show the review, that's it.
Let me see.
MUC judgment exhibit R2. MUC judgment exhibit R2, my lord.
This he has produced. This endorsement is produced along with the review petition.
Yes.
Based on that, insurance company is made liable.
Name of the DL holder, MR Renuka.
Insured, my lord.
Yes, insured, my lord.
Why it is relevant?
My lord, investigation officer is a charge sheet is filed against the driver of the Venkatesh, my lord. The initial Venkatesh is no driving license, my lord.
Then?
But already paid recovery is.
Pay and recover. What is the reason for the court to review this order? And you need to file 2 appeals, is it not?
My lord, in the first instance, my lord, I was exonerated.
Yes.
Only in the review petition, I am made liable, my lord.
No, practically there has to be 2 appeals against the original order and the review order.
On review, I am before this honorable court. My lord, in the MVC judgment, owner is made liable. Therefore, he filed review petition before the tribunal.
No, the whole issue is the court has given a finding in the original order saying that the driver of the deceased was not having a valid driving license. Now, if that findings have to be altered, the driving license or endorsement of that driver has to be,
Produced.
how can it be of the owner of the vehicle?
But in this case, not a dispute of the accident, my lord, but a dispute between the owner, driver and insurer, my lord. I am the third party, owner of the
You're not
claimant.
Yes. Yes.
Internal page.
Then in that case,
But at the time of accident, my
so
lord,
what will happen is,
yes,
if only this review order has to be looked into,
No.
then even in that review order also we'll say that, no, what will happen to the original order? There the court said that even pay and recovery is also not ordered.
but
Then the claimant has to file an appeal.
no, my lord, I'm not to file the appeal announcement.
Why?
My lord, a review petition, my lord, insurance company are liable, my lord. Pass an order, my lord.
Now what happens? Now the review order, if the court says it is wrong,
But they have challenged the, not challenged the charge sheet, my lord.
please understand what the court is saying. Now, if the court says review order is bad, what is the review order? Considering the driving license of the owner of the vehicle is bad. If that is set aside, what will happen? The original order which is passed by the court
Will remain.
where pay and recovery is also not ordered will remain. You should be aggrieved by this order. And you should have preferred an appeal against this.
Not filed the appeal, my lord. Claimant is not filed the appeal.
File it.
Please.
Two weeks.
Much.
This is matter after 2 weeks.
Number 3. What will it be?
I'm appearing for the respondent number 2.
Insurance company appeal challenging the liability on the ground that, my lord, the driver was not having a driving license. I have issued the notice to the owner of the vehicle to calling upon him to produce the driving license of the accused charge sheet driver. That was not.
Charge sheeted should not.
May I have one submission in this matter? May I submission? Lord, on 28 January 2017, Lord, I have filed an application along with document regarding, my Lord, 41 Rule 27 application. In my application, my Lord, clearly stated that, my Lord, they have issued a notice. My Lord, the date of accident is 4/3/2008. The insurance company calling upon the owner of the vehicle to issue a notice on 13 September 2013. Thereafter, my lord, I will produce the entire document to the insurance company. I will produce the same before this honorable court, my lord, in 41 to 27 application. The owner of the vehicle, my lord, produced all the details regarding the vehicle involved in the question of the accident.
Whether he has, along with that, now the driving license is there.
Please.
It
What are
may
your
be have it on
objections?
any other day, my lord.
Yes, it is submitted that the respondent has already filed an application of order.
In the year 2017, I filed.
And the land counsel for the insurance company wants to verify the same and submit. This is matter when? Yes, Mr. Shivanagada, when?
Any other day, my lord. Pradeep has to come.
Second.
I have to ascertain from him.
Second.
Please.
4.
Fourth, week's time will come. On second one. Fourth also.
2, 4.
Don't ask for further time, 15 matter.
He is not in station due to some other reason. That's the
Yes.
reason.
Dismissal. Serial number 5.
I appeal for the appellant.
Yes. Who appeals for respondent? You are on what ground in the appeal? On
Appeal, my
liability.
lord, on liability that he didn't have a license, my lord, as on the date of the accident. RTO, my lord, was examined.
Paragraph number, finding.
Finding, my lord,
We'll have it in the afternoon.
Yeah, please.
My lord, may I make one suggestion? My lord, in serial number 7, my lordship has called me. Take notice, my lord. Serial number. Take notice, my lord.
No, what we'll do is, implead petition is filed, so and so is taking notice. Like in other matters, we'll give a direction for them to implead you. That would be better. By instead of,
Proposal respondent.
for the proposed, the beneficiary shall be made.
We'll be party here and then litigation. We will write in the.
Let's not waste that time again. And the, what is your number? Serial
Serial number 7, wish number 2.
I number so and so is filed, seeking to implead so and so. Then counsel Mr. Prashant BR submits that, is taking notice on behalf of the respondents. In the connected matters, already certain orders are passed remanding the matter and directing the appellant the claimants to implead the beneficiary as a proposed respondent. In that view of the matter, this court has the order so and so in so and so is set aside, and the matter is remanded back to the trial court. In the other orders, KA is also taken, and all the orders, whatever are the conditions, including the beneficiary's implement, everything will be there. Same order.
Refund of court fee also.
Court fee also will be refunded.
Whether we have not included here.
No, not here. There only. We'll say the finding is given, and also said that you are taking notice for all practical purposes.
That is, my lord.
That's a difficulty.
My lord.
They don't get the fees.
That is the.
Then counsel so and so submits that he takes notice on behalf of the proposed party. Accordingly, IN number is allowed. Accordingly, IN number is allowed, and so and so shall be brought on record as the so respondent number 3. Respondent number 2. The necessary amendment shall be carried out to the cause title and will also the disposition. court had taken?
Court has taken 7,000.
Huh?
7,340. 10,000 it is taken.
As per the chart, it is 12,000.
Please.
According to him, how much is earning?
He was earning according to him 15,000.
15,000. Dependents?
Wife and children.
Hmm.
One
One
third is
son.
deducted.
Wife is the only dependent.
One son and one daughter is there.
They are also claimants.
They are also claimants.
What is their age?
One son is for 35 years and daughter is
Aged.
40.
But court has deducted one third.
So now, we have to, yes.
That appellant number 3 is also an agriculturist.
Appellant number?
3 is also an agriculturist along with the father.
No, court had considered 3 persons as
One
dependents.
third is correct, Millard.
What else you want? No, court has considered 3 persons as dependents. So, 12,000, future prospects?
Millard, 68 years.
68.
No, but
12,000.
tribunal has granted.
Huh?
Tribunal has granted. But 68 years he is not entitled to get that.
12,000. One third is deducted towards personal expenses. How much it comes to?
8,330. 33.
Is 4,000.
Pardon?
4,000. Then remaining is contribution 8,000 into 12 into multiplier.
Multiplier, Millard, 5.
It comes to 4,80,000.
Please. 1,20,000 under consortium.
Already granted.
Is granted. So escalation has to.
No, 1 minute. 3 into 44 is 1,32,000.
Please.
And Shundal expenses?
30,000 it is
36,000.
granted, 33,000.
36,000. That also escalation.
Please.
Legal expenses 10,000. It comes to 6,58,000.
Please.
How much is awarded by the tribunal?
Tribunal has awarded
It is 5,50,020 rupees.
5,50,020.
Even after the modification of the order, my lords.
5,50,000?
20 rupees.
20,000 and 20 rupees.
5,50,000.
50,000.
20 rupees.
5,50,000 20 rupees.
20 rupees. Which is the MVC number?
5990 of 80.
5990 of 2018.
Please come. Agreed with the orders passed in MVC number 5990 of 2018. The claimant is before this court seeking enhancement of the compensation.
There is one more submission, my lord. I'm sorry to interrupt. There is one more clubbed MUC case by the appellant number 3. Is also a claimant in this case,
How can it be?
because the appellant number 3, who is also the deceased at the time. I mean, sorry, he was the injured in the said
No, there
incident.
are 2 MVCs.
There are 2 MVCs.
You need to file 2 MFAs.
Actually, earlier the order has been passed by common order.
No, you cannot.
Still you will file 2 appeals. How can you file 1 appeal?
The earlier advocate has clubbed and filed this MFA. So that's why actually the compensation for this, the second MFA, I mean the clubbed in this case, we're seeking a higher compensation.
How can it be? How can you file?
No, common judgment was filed. Common judgment, separate petition was filed, madam. Common judgment was filed. He has to file 2 appeals.
The office,
Cannot seek the compensation in one appeal for two.
the office objection is entire appeal to be restricted to a single case like that. The office has been raised the objection.
It has to be. That is rightly taken. No, we'll give it liberty to file an appeal in respect of.
Please, my lord.
No, this is in respect of which case?
That is for
600 of 19.
600. So this order is already there, condoning delay. The office has raised the objection with regard to maintainability of this appeal in respect of two claim petitions. It is a submission of the learned counsel by the appellant that as a common order is passed, they filed one appeal, which is not permissible. In that view of the matter, this appeal is restricted to as appeal arising out of MBC number 600 of 2019, and in respect of MBC number 599.
This is respect of 5990.
It is restricted to 5990 of 2018, and in respect of MBC number 600 of 2019, the appellant is at liberty to file an appeal within 1 week from today.
Lord, at least 2 weeks, my lord. At least.
Already giving that liberty itself is a big thing.
My humble request.
2 weeks from today.
Much obliged.
Next. A docket order. Accordingly, the office objections are sustained. Agreed with the order passed in MBC number 5990 of 2018 dated. Where is the date of order?
It was on
That is also not forthcoming.
16th of December 2021.
But 21.
16
December 2021.
16 December 2021. The claimant is before this court seeking enhancement of the compensation. It is a case of the claimants. The claimants are 3 in number, the wife and daughter and son. It is a case that the deceased was working as an
Agriculturist.
agriculturist, age 68 years, and earning 15,000 per month. Court had taken 10,000 as income, and considering the 3 dependents has deducted 1/3 and granted the compensation as per the table given below. That is page number 30. Learned counsel appearing for the claimant submits that the accident had taken place in the year 2018.
18.
The court ought to have, the court at least should have taken 12,000 as an income, and taking income at 10,000 is on the lower side, even on the conventional heads also. The amount that is granted by the amount that is granted by the tribunal is on the lower side. Next parallel, counsel appearing for the respondent insurance company, Mr. P.C. Sivanagowda, submits that the court had rightly granted the compensation basing on the evidence and no interference is called for. Next, having heard the counsels on either side, there is a material on record. This accident has taken place in the year 2018. Considering the chart prepared by the Legal Services Authority, this court is taking income at 10,000. Taking the income at 10,000. Taking the income at 12,000. As there are 3 dependents, 1/3 has to be deducted towards personal expenses. That is 400. Then the contribution to the family would be 8,000. At 8,000 into 12 into 5, the loss of dependency would come to 4,80,000 towards consortium. In the light, as there are 3 claimants, 1,32,000. Funeral expenses 36,000. Legal in the light of the law laid down, legal expenses 10,000. Altogether, the claimant is entitled for an amount of ₹6,58,000. Accordingly, the appeal of the claimant is allowed by enhancing the compensation from 5,50,000 to 6,58,000.
I mean, permitted to file wakalat in a week.
Mr. Sivanagowda is permitted to file wakalat within 1 week?
Please, they have already forwarded. May reach to my office.
Within 1 week.
Grateful.
Serial number 11. O Mahesh,
Appear for the appellant.
Yes.
I appear for the claimant.
What is the cross objection, my lord?
I am for the cross objector.
There is no complaints, my lord. When certain objections raised by the office.
Huh?
Cross objection, my lord, by the insured.
Huh. No, there are so many, this is it's coming in interlocutory. What are this? A number 106 not pressed by advocate for applicants is all the entered appearance. Translated copy not required. In 11.1,
11.1.
what is 1 of 16 for dispensation?
Dispensation of certified copy.
Then we'll order first that, and there is delay, that also
Yes,
has to be ordered.
delay is there.
IA 1 of 16 is filed, seeking dispensation of correction of the certified copy of the judgment. Of the award dated 26/6/2012, passed by the 2012. The same is IA number 1 of 16 is allowed, and by dispensing with the same. IA number 2 of 16 is filed to condone the delay of 34 days in filing for the reason stated. The delay is condoned. Then
34 days delay, my lord.
non-filing of, that is condoned.
Please, madam.
Non-filing of translated copy of the documents which are not. Wakalats for R3. Who appears for R3?
I appear for R3, my lord.
You have not filed the wakalat.
I have yet to file wakalat, my lord, because the copy was sold only recently.
Non-filing of wakalats for R1 and R2. R1 and R2 whom?
My lord,
Kavita.
R1 and R2 are the claimants.
Respondents in the connected appeal, my lord. I may be permitted to take notice in this appeal. I'll undertake to file wakalat.
So to be here, to hear this matter now or not?
My lord, I appear for the claimants. It's a 10-year-old appeal, my lord. Date may please be fixed in case, my lord.
Let us this matter on second at the request of learned counsel for the respondent number 1 and 2, and she submits that she undertakes to file wakalat by the time. Yes, next.
Please 2, serial number 8.
Yes.
Sorry, my lord, morning, my lord.
I know. No, what is the because ultimately he will be losing his right of appeal.
Right up.
That's it. That's the only thing.
Oh.
So if he is ready to forego that, you can't have any difficulty.
No, my
We'll
lord.
allow it.
Please, my lord. My lord, my only submission is, my lord, the suit for injunction. That is, other suits are, my lord, declaration and injunction.
No,
Two
even on the merits of it also, they already asked
Please.
him. Even on the merits of it also, the court will decide whether
Please,
such
my
a, when he has already sought a declaration, can he independently seek injunction and all, the court will decide.
My lord, my only another submission is, my lord,
Hmm.
my lord, there is a delay of 1,575 days in bringing the legal heirs of respondent number 8. My lord, with cost, my lord.
Ultimately.
With cost.
Ultimately, so pending suits, everything will be decided. Yes, give the file. Unnecessarily, it's been kept pending right from 2018.
My lord, the only for, my lord, not bringing the legal heirs of, that's why. My lord, we have reported the much earlier, my lord, we have reporting the death of respondent number 8.
The present petition is filed. Seeking transfer of RA number 8 to 85 of 2016, pending on the file of the first edition district and session judge, Davangere, and transfer the same to this court to be tried along with RFA number 1413 of 2016 and RFA number 1841 of 2016, pending before this court. Learned counsel appearing for the petitioner submits that the petitioner had filed OS number 10 of 2009 on the file of the
Senior civil judge.
Huh?
Senior civil judge and MA Harrier.
Ariara.
on the file of the senior civil judge
and MACT.
Hariara, and
Hariara.
thereafter it was transferred to the yes, Seeking injunction. declaration and No. First is injunction, 10 of 2009.
10 of 2009, my lord, it is for declaration. Declaration and injunction.
My lord, OS 41 is, my lord, the injunction.
Morning, that's what I said.
41 is injunction.
And corrected, my lord.
OS number 41 of 2009 is filed on the file of so-and-so seeking injunction by the petitioner herein. He has also filed OS number 10 of 2009 on the file of?
On the file of the learned civil judge, the
Hariara seeking,
Yes.
where do you mention those? Please come to your facts.
Please, madam.
The court's name.
Please, madam. Paragraph 2, my lord. In page 5.
OS number 10 of 2009
Yes.
is filed with the petitioner on the file of the senior civil judge Harihara for declaration of title in respect of the scheduled properties. The OS number 135 of 2007 in respect of the very same property, the respondent herein has filed the suit that seeking declaration and
permanent.
recovery of possession,
And also mandatory injunction.
and also seeking mandatory injunction on the file of the senior civil judge and MACT at Harihara. The OS 41 of 2009 is filed by the petitioner on the file of the senior civil judge and MACT Harihara seeking declaration.
Seeking permanent injunction.
Permanent injunction. 41 is permanent.
Permanent injunction. The court had clubbed all the three suits and passed a common order whereby the suits filed by the petitioner as well as the suit filed by the respondent were dismissed. Thereafter, against the orders filed in the declaration suit, RFA number 1413 of 2016, RFA number 1841 of 2016 are filed by the petitioner as well as the respondent. As far as the suit for injunction, that is OS number 41 of 2009 is concerned, the same was as it is, it was an appeal is filed on the file of the district judge Davangere.
In RA 85 of 2000.
Davangere, that is RA regular appeal 85, RA 85 of 2016. Now, the present petition is seeking transfer of that RA 85 of 2016 to be transferred to this court and to be tried along and to be decided along with the pending RFAs. Learned counsel appearing for the petitioner submits that the property, the parties are one and the same. And now if now if these cases are decided separately, there is every scope for conflicting of judgments, and which is not, it would cause a lot of hardship to the petitioner. He submits that the respondents cannot have an objection, as if the same is transferred to this court, the petitioner would be losing his right of appeal, and the respondent cannot have any objection for transfer of the same. Learned counsel for the respondent submits that as all these suits are pertaining to the parties pertaining to the same property and between the same properties, he has no objection to transfer the same. Accordingly, this court is passing the following order: so and so pending on the file of so and so is transferred to this court to be heard along with RFA number 1413 of 2016
and
RFA number 1841 of 2016. Accordingly allowed. Number 25.
For appellant, my lord. This is the
State for the appellant, you know. Appeal by insurance company and question liability.
Is he here? No, it's 25 in list number,
This is the
List
dependent.
number 3, serial number 5, my lord.
No, sir.
tell him.
Sir, list 2 serial number 25 कर दीजिए sir.
Oh, sorry, sir.
Milord, I am appearing for the appellants, Milord. Defendant 2 and 3 appeal, Milord. The respondent number 1 is the plaintiff before the trial court. Filed a suit for relief of declaration and title and possession. The trial court dismissed the suit. Agreed by the said judgment, Milord, they have filed appeal, first appeal before the senior civil judge. Milord, first appellant court, Milord, has reversed the judgment and set aside and remanded to the trial court for appointment of commissioner and to locate the property. Milord, the basic suit is for the relief of declaration and title. Milord, their contention is exhibit P1 is the title document.
You're the
I am the defendant number 2 and 3.
suit is for declaration.
Declaration of title and possession. Milord, the trial court clearly held that, Milord, they have failed to establish the identity of their property as per exhibit P1. The boundaries given in exhibit P1 is contrary to their own schedule given in the plaint. Since he has also admitted during the course of cross-examination, as well as he has failed to locate the property. Therefore, trial court has rightly dismissed the suit. Not agreed by the judgment, they went up to first appellant court, Milord, is though in the appeal, Milord has considered the document exhibit except exhibit P1. No other documents are produced.
Please come to the finding, reasoning part, please come.
Yes,
Of
Milord.
the appellate court. Please read.
Reason, page number 29, Milord. May I read relevant, Milord, portion. Para number 21, Milord.
Yes.
In order to prove her case, plaintiff got examined herself PW1 before the trial court, hereby testifying that land in survey number 158 measuring 3 acre 39 guntas of so and so village was acquired by government from KV Nanjun Reddy and son of Venkat Reddy for a formation of sites, construction of houses for allotment of the same to houseless people of so and so village under Ashraya Yojana, and therefore she being the houseless lady, she moved an application for allotment of a house to her, and accordingly the government granted the suit property to her on 22/2004 in Ashraya Yojana in so and so number and certificate dated so and so with a condition that property shall not be alienated or encumbered in any manner for a period of 20 years. She further testified that on this basis of grant, she and her family members have been in possession of the scheduled property. She further testifies that the father of the defendant number 1, namely Muniappa, being her relative, requested about 5 years ago to accommodate him in the scheduled property till he construct a building in his property. Accordingly, considering the relationship, she permitted to use the occupy the scheduled property under the permissive possession on a monthly rent of 5,500. She further testified that after completion of the building of the father, defendant 1 and through her requested him to vacate the scheduled property. He refused to do the said denial of the title of the scheduled property and also illegally indicted the defendant number 3 as a sublessee in the suit scheduled property without her consent and knowledge. She also testified the father of the defendant number 1 expired about 1.5 months ago. Thereafter, also even prior to thereto, she conveyed the panchayat and issued a legal notice, and but the defendants and father of the defendant refused to vacate the suit scheduled property. Therefore, she filed the suit for so and so. Milord, in support of, may I read a relevant, may I go, Milord?
Yes.
Milord, the reasons to interfere of the first appellant court judgment, Milord, and the trial court judgment, Milord, is that the para 24 may kindly look at, Milord. The counsel for the defendant has cross-examined the PW1 at length. It is true that at page number 3 of our cross-examination, PW1 has admitted a suggestion to the effect that she has mentioned the wrong boundaries of suit property towards southern side and that the house of one Murugesh is located towards the said direction. However, this answer does not make the description of suitable property given by the plaintiff improper, since description given by plaintiff on the basis of grant certificate marked as exhibit P1, the same cannot be said as improper.
No doubt the defendants have strongly disputed the grant of the suit property in favor of the plaintiff in the suit, but in cross-examination, DW1 and 2 have clearly admitted the said fact. Counsel for the plaintiff has cross-examined the DW1 and DW2 at length, and page number so and so, that is my lord, in the Kannada version, that is stated that property survey number is 158 and it was belongs to one K. Nanjun Reddy, and the site, my lord, is allotted by the government is the description of that evidence, my lord. Lord, finally, my lord, trial court, my lord, first appellant court come to the conclusion, para 26, saying that in view of the above answer, it is clear the defendant do not dispute the allotment of property by government in favor of the plaintiff, but they claim that said property is not the suit property but some other property. DW1 has gone to the extent of saying the property allotted to plaintiff is not suit property by adjoining property. Similarly, DW2 further stated the document produced by the plaintiff, such grant certificate, etc., are not cancelled by any authority. Thus, in view of the DW1 and 2, since the grant certificate of plaintiff is not cancelled by government, the said grant certificate is not declared to be null and void by any authority. Since the defendant to admit the allotment of property by the government in favor of the plaintiff, this defense of defendant of suit property is not the property which allotted to plaintiff is not believable and acceptable. The defendant admit the property is allotted to plaintiff exhibit P1 grant certificate. It clearly shows that property with the description given in the plain schedule itself is allotted to the government. Thus, the plaintiff has placed sufficient material on record to show she has granted the property. But these findings, again contrary to the paragraphs Millard is mentioned in subsequent paragraph, the entire case of the plaintiff Millard is that they let out the property to the D1 and 2. D2 Millard has sublet the property to the D3. Millard, for that, Millard, as a first appellant court has clearly come to the conclusion, para 32. Just look, Millard, if they want to prove that I am a sublessee and possession of the property, para 32 finding, Millard, is may kindly look at. Appreciated para 32. Page para 32. Thus, in view of the above discussion, it is clear plaintiff proved the suit property granted to her and not show the grant certificate of plaintiff is illegal and set aside cancelled by any other. However, this aspect not at all considered by the trial court in the impugned judgment held in the plaintiff and failed to prove the suit property or property of the government and also are entitled to the suit property. But trial court has not erred in holding that plaintiff has failed to prove the permissive possession of father of the defendant number 1 in suit property, so also sublessee of the defendant number 3 in the property by the defendant 1 and 2. The trial court has not erred in holding the plaintiff has also failed to prove the defendants are in arrears to the rent to the scheduled property. This indicates, Millard, we are not in possession of the property, we are not a sublessee. But on the contrary, we have produced the document before the court what the defendant is in possession of the property is by way of registered sale deed. When the first appellant court has answered that, Millard, is that it is not trial court.
All these documents are pertaining to some other property and not the suit. No, your documents I'm reading. Page number 38, court says,
Some other property which we are in possession, they are claiming that to seeking possession. That's why trial court held, Millard, they are not in permissive possession, the defendants are not in permissive possession. The issue number 2 and 3 has answered as a negative, saying that plaintiff has failed to prove that the defendants are in permissive possession. On contrary, we produced the document we produced is the property by virtue of the sale deed we are put in possession. Same has been appreciated by first appellant court in para number 33. I read, Millard, just now page 39. May kindly look at, Millard. When this is page 39,
no.
Middle of 4 lines.
Start reading from 32.
32. Thus, in view of the above discussion, it is clear the plaintiff has proved the suit property is granted to her by government as defendants have not showed that the grant certificate of plaintiff is illegal or it has been set aside or cancelled by the any authority. However, this aspect is not at all considered by the trial court in the impugned judgment. It is erroneously held the plaintiff has failed to prove the suit property in her favor of the property. Government also her title to the suit property. But this is may kindly appreciate. The trial court has has not erred in holding that plaintiff has failed to prove the permissive possession of the father of the defendant one in the suit property. So also sublease of the defendant number 3 in the property by the defendant number 1 and 2. The trial court has not erred in holding that plaintiff has also failed to prove the defendants are in arrears of rent in her respect of suit schedule property. So, my lord, this aspect of admission.
Complete that. You know, it's a small judgment.
Yes, my lord.
Another paragraph.
However, it may be noted that in this case, plaintiff claiming the defendants are in possession of suit property, whereas the defendants are claiming they are in possession of their own property, which is not suit property, but it is an independent of the suit property. It is true already above that plaintiff has not proved that the defendants are in permissive possession of property, but they may be in possession of suit property in the some other position. As such, if the defendants are really possession of the suit property, whatever may be in the nature of their possession, they are also liable to vacate the same and hand over the possession of the same in favor of the plaintiff, because suit property is allotted to the plaintiff and their possession is suit property with would amount to a wrongful possession. However, if the defendants are not in possession of suit property, but their own property as claimed by them, they are at liberty to continue the possession of their property. Under these circumstances, plaintiff would still be entitled to occupy the suit property without intervention of the defendants. Therefore, when there is no doubt as to ownership of the plaintiff for the suit property, when the defendants are claiming their property is independent of the suit property, I am of the opinion that controversy whether the property is in possession of the defendant is the suit property or independent property, and whether the defendants are in possession of the suit property or a different property can be resolved only by conducting a spot inspection and by noting the existence of suit property and property of the defendant on the basis of description given by them in the plaint as well as written statement. As such, trial court ought to have considered these aspects and ordered the appointment of commissioner in the suit for the above purpose on its own motion, even without waiting an application by the 5 parties. If the court commissioner is appointed in this case by this court to conduct the spot inspection of the suit property, that the defendant, if he reports that the property claimed by the defendants is nothing but suit property, if he also reports that defendants are in occupation of suit property, the plaintiff would be.
What is the prejudice cost to you now?
Lord,
The prejudice to you.
Lord,
If the matter is remanded, you're saying that
we are
the
in
property,
possession.
the suit scheduled property and your property are not one and the same.
Not one and the same. They are not in possession, and we are in possession.
You are claiming independent possession, independent title.
We have.
It is not your case that the property which is a suit scheduled property where you are residing.
It is not my case.
So even if the matter is remanded to the court, if the plaintiff's title to the property will be decided. No, the undisputed fact is that the government has allotted the land to the plaintiff. And plaintiff is saying that you are the tenants. That aspect she could not prove. And according to you, these are two independent things. What the court said, everything is available before the court. If this spot inspection is done, it will be known whether this property and that property, what you are saying, is one and the same or not. If it is not one and the same, then the plaintiff has no right to sue to proceed against the defendant. If you are in the plaintiff's property, that will clinch the issue.
That exercise cannot be done by way of first appellant court, since for the simple reason, Millard, is that the remand of the matter will considered under 41 rule 23. May kindly look at Millard. Order 41 rule 23, while exercising the power in a first appellant court, remand of the court, Millard, first they have to independently prove their title over the property, and when the opportunity provided in the trial court, they did not exercise that power as a favor.
Before going into that, after reducing all the evidence, when all the material is before the trial court,
when this simple exercise would
Madam,
have given a finality to the dispute between the parties, that should have been done by the trial court, which the trial court had failed to do. Now, when you're saying that you are not in the property, this property, you have your own independent property, how are you bothered?
Madam, defendant it is not the case of defendant not come before the court. Plaintiff approached the court. He cannot take any weakness of defendant for the simple reason that he admitted that we are, and they categorically trial court as well as the first appellant court has come to the conclusion that defendant is in possession of the property. He is not a tenant or sublessee. When that finding is recorded by both the courts, then automatically, my lord, the plaintiff is not entitled for the relief of declaration of title and possession.
It is your own case that the suit scheduled property and your
Different.
property are one
That's
and the
why
same.
once the plaintiff himself admitted that when the both the courts below has clear finding, my lord, is contending that the property in possession of the defendant is separate property and plaintiff is nothing to do with that property, then ultimately the plaintiff has to prove before the trial court this suitable property is my property and I am entitled for the relief of declaration.
As it is the stand that
Not
you have taken.
except a grant certificate, no single scrap of paper to produce. They are in possession. They are having a title.
That is not your property according to
When my property is not there, what is their case, my lord, before the trial court? I am paying a 500 rupees rent to the defendant number 1 and 2 paying rent, and they let out the property to construct the property in the other side of the property, and on the 500 rupees rent he was put in possession. After construction of house, he did not vacated the property. But such is the case. Both the courts finding what is, my lord, appreciated on the evidence, my lord, till this day. What is material evidence placed before the court? The plaintiff has put in possession of the defendant 1 and 2 before the suit filing that they are put in possession. They are collecting rents. They are the tenancy rights have been created. They are a sublessee the property. That is concerned. Nothing is there. But once the court very clearly, my lord, has findings of first appellant court also that they failed to prove that I am a tenant. My vendor is a tenant. I am the independent property in possession.
He is seeking declaration to the property to which he is the owner of the property.
Let
that
them,
property and your
unless the law is very clear. Unless and until identifying the property, no declaration in injunction can be granted. But in this matter, PW1 admitted, that was I already read before the court, my lord, in para number 24 of the first appellant court judgment, contending that southern boundary is wrongly I have given. Southern boundary once wrongly given, the court say first appellant court held merely giving southern boundary, it cannot be a proper to declare the plaintiff is the absolute owner of the property. That is the finding one. Second finding, my lord, is that first appellant court remanded the matter on the ground that exhibit P1 is a grant certificate. So exhibit P1, once it is there without cancellation.
Also admitted that there is a grant.
Allah, once the grant is there, once grant certificate is there, it has to be declared as he is the owner of property. What is the prayer and what is the pleadings? What are the issues before the trial court? May kindly look at the trial court judgment as well as the first appellant court judgment. Where the issues, my lord, core question involved is that whether the issue number 2, whether the plaintiff proves that defendant father was given a permissive possession of suit property, please kindly appreciate suit property, and he along with the defendant 1 and 2 indicted the third defendant in the suit property on the sublease without consent of knowledge. But they have to first prove this is a suitable property granted to him. They are placed at exhibit P1 is the grant certificate. Next question, my lord, is that this property has been let out by the plaintiff to the defendant 1 and 2. But both the let out property is which is the possession of defendant number 3 is not the suitable property, and plaintiff has utterly failed before the trial court as well as first appellant court. Once they fail to prove their possession, which is the possession of the defendant 1 and 2 is the suitable property, no declaration cannot be granted unless and until proving that this is the suitable property.
You are not at all
Yes,
concerned.
yes, my lord, I am.
You are not at all concerned. with
Madam,
the
whether in a suit for declaration.
his suit. That is his suit.
Madam,
You
it
say
is
that
in suit.
No, that is his suit. Now, the finding as far as your concern.
Who has to prove, my lord?
Will prove.
He has not proved the trial court answer. The trial court answer is.
He need not be the aggrieved person at all.
My lord,
Because court has said that Court has recorded that what all the documents that you are relying on are not pertaining to the suit schedule
Correct.
property.
The ultimately the possession which I am in, they are trying to guise of the declaration of the suit. Trial court matter remanded to the trial court. I am contending that exhibit P1 is the property. Identify and locate. Court finding is that if the commissioner appointed, if the commissioner given a report to the court saying that on the report, if the property comes of the defendant is in possession of their property, then the plaintiff is not entitled. If the court commissioner reported that if the property in possession of the defendant is the plaintiff scheduled property, that exercise will not be done by the court based on the commissioner evidence.
In a suit for declaration.
Yes.
After.
Yes, my lord.
What the court is saying.
Yes.
In a suit for declaration, and after both the parties have adduced their evidence, and everything is on record, and at this stage, if the court feels appointment of commissioner is required, it is always the court has the power to do it.
That exercise
has to be done by the
41
trial
rule 20
court.
Supreme Court, I may be relying on this judgment. Kindly look at, my lord, this judgment.
Yes. Yes. Paragraph number.
This judgment, my lord, the scope of 41 rule 23 as well as the honorable affects court, my lord, is clearly held that the remand, para number 7 and 8 may kindly look at, my lord.
Yes. 7 is not relevant. 7 and 8 is on facts.
But 7 and 8, what the law, my lord, is that in a suit for title and possession of the means profit, burden on the plaintiff to prove that his title to disputed land.
Where are you reading?
Para 7 and 8, my lord.
7 starts in appeal before us, Mr. Saroj Prasad.
Yes, my lord. Where may kindly look at, my lord? 3 lines after, my lord. May I read? I may be permitted to that, and the words exactly started, my lord, is that Mr. Saroj Prasad on behalf of the appellant has made a number of contentions, but in our opinion, this, my lord, our opinion, it is not necessary to go into all them in the appeal. He is liable to be dismissed on the short ground that plaintiff appellant have failed to establish that land dispute is same land has been purchased in action by Manian Karur as per the sale certificate dated so and so was thereafter leased on behalf in favor of the appellant as per the 2 registered lease deed. But this is I am reading. Similar circle.
No, you have
para 7.
Paragraph 7 starts.
In appeal memo, in appeal before, your lordship. Second line may kindly look at, my lord. But in our opinion, your lordship find out. In our opinion, it is not necessary to go into all of them for all of them. For an appeal, is liable to be dismissed on the short ground that plaintiff appellant have failed to establish that land in dispute is the same land has been purchased in action by Manian Karur as per the certificate dated so and so was thereafter leased in favor of the sale certificate dated so and so was thereafter on behalf of in favor of the appellant as per 2 registered sale deed. It is not disputed that it is if on the above view the matter is appellant are found to have not proved their title of the land in dispute, the question of going into other contention would not arise. However, they submit the defendants did not dispute the trial court the land in dispute same which has been purchased by Manian Karur in action sale and has been leased. We find it difficult to accede to this submission in para so and so. In the same language, it is touched para 14 of the written statement that it was incumbent in the view that amendments in para 15 of the written statement for the plaintiff appellant to establish by clear evidence that land in dispute was the same which has been purchased by action sale by Manian Karur and there has been subsequently leased so and so. The judge of the court discussed the oral and documentary evidence which has been adduced in the case came to the conclusion that there was no cogent material to show that land in dispute was same which has been purchased by so and so had been leased in her favor in the appellant. After hearing the so and so land has been purchased by was situated. The land which is subject matter of the present litigation is situated. She had this district so and so. Our opinion, the land in dispute, Sharabad district represents the land which got submerged in the result in the river action of so and so. Next, my lord, relevant portion, my lord, is that para 8. And the last 4 lines, my lord.
Yes.
To remand, the word started, my lord. To remand the suit to trial court would necessarily have the effect of keeping alive the strict between the parties, the prolonging this long drawn litigation by another round of legal battle in the side trial court. Thereafter, in appeal, it is the time, in our opinion, that we draw the final curtain and put an end to this long meandering course of litigation between the parties. If the passage of time, the loss of nature bring to an end in the lives of the men and women, it would be perhaps be due to reason and dictate to produce the not to keep the alive after so many years of the strife and the conflict is started by the dead. To do so would we affect by defying the loss in the nature and offer in failing the resistance to the revenge of the time. If a human life is not spared, it would be irrational to entertain the dollar claim of the dispute and conflict, which are manifestations of human ferality. The court should both to entertain the plea that in a case like a present, which would have effect considering the succeeding generation of the families to spend the major part of their lives in the protracted litigation. In our, it may be appropriate in this one so case. In the above, it is being held that it may be equally true affairs of the mortal beings, their disputes and conflicts, their so and so. Our feels the temper to that if the life is like a gem of many colored glasses stained with white readiness and entirety. So do doing the conflicts of mortal being fill the depth of temples of the down. Therefore, the appeals fails and dismissed and so on so. What held, my lord, is that when there is a findings with regard to the declaration of title and possession, remanded when the plaintiff failed to prove that he is a lawful title over the property, the question of remanding matter not allowed in view of the unequivocal averments in the written. Because in this case on hand, my lord, is that plaintiff contention that defendants plaintiff has let out the property to D1 and D2. D1 and D2 sublet the property to defendant number 3. The material on record, my lord, produced before the court to show that he has both courts, my lord, as a concurrent finding saying that the possession of the defendant is they have failed to prove that we are the sublessee. We are in possession of the property on an independent title. On the other hand, the court, my lord, is held that if the court commissioner appointed, then only the truth will come out whether who are in possession of the property. Whether the property in possession of the defendant is the suitable property or not. That cannot be exercised by collecting an evidence by the through a court commissioner.
So do you accept, that's what I'm repeatedly asking you. When the matter is,
we are not disputing,
no.
Even you granted some land. How do you say that this property we are in possession
That's not what I'm asking. That's not what I'm asking. You're assuming something even before the court asks you. I'm saying in a suit for declaration, everything, all the evidence, both the documentary and the other evidence is before the court. At that time, can the court appoint an advocate commissioner or not?
That situation comes.
No. Simple question. Whether court has a power, and at that point of time also you will say that court has no such power to do it. It has to be independently done by them, independently proved by the plaintiff. That's the only simple answer to that.
My answer to that, Milad, is that
at the trial stage, I'm asking. At the trial stage, if the court feels,
court cannot exercise that power.
No, I'm saying at the trial stage. I didn't ask you at the first appellate stage. Court can do it or not.
But if that situation comes, court has to power.
Has the power. When all the material is on record at the stage of arguments, if the court feels it is required, court will do.
normally, but the question will not before the court is that in this case at hand, in the trial court feels that first of all, the plaintiff himself has failed to prove that defendant is in possession of suitable property. Court feels and court recorded a categorical finding that they have they have a document of sale deed. Based on the sale deed, they are in possession. They are nothing to do with though they are nothing to do with the suitable property. They are in possession of they are based on their title deeds. Based on the title deeds, Milord is they are in possession. The ultimately question, Milord, is that the plaintiff has failed to prove their possession over the property. Merely a title grant, merely because of exhibit P1 grant certificate, they are claiming that this is their property, they are the owner of property. We are saying we are nothing, your property somewhere else, you identify it. You are not doing any, that's an exercise, you are not produced any document to show look, Milord, in the government it is a granted property under the Australia Yojana scheme. Milord, there must be a plan. It is also an admitted that survey number 158 is a larger extent of 3 acres and add, wherein a site was allotted to them according to them. A plan has to produce and they have to prove that this is the property. Admittedly, on exhibit P1, it is a vacant site. When it was constructed, when he has let out the property to D1, utterly failed before the court. That's why trial court has rightly dismissed the suit.
Please come.
The evidence, Milord, is I need to read the deposition of PW1 and 2.
Yes.
It is in Kannada language.
What is that you're relying on? You can tell.
They himself admitted that the property they are not in possession. The property which we are in possession, which property? The suggestion clearly indicates that the defendant is in possession of their defendant written statement to be property by virtue of the sale. That piece of evidence is very important. But I also extracted in my appeal memo.
Let's see.
Page 11 of appeal memo. Grounds, Milord. But it is in Kannada, Milord.
Read it and tell the court what is it.
Yes, Milord, I will also. Page 11, cross-examination of PW1 dated 29/9/2020 is 2011. ದಾವಾ ಸ್ವತ್ತು ಎಷ್ಟು ವಿಸ್ತೀರ್ಣ ಇದೆ ಎಂದು ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. It means what is the measurement of suitable property? He doesn't know. ನನ್ನ ಮಗನಿಗೆ ಗೊತ್ತಿರುತ್ತದೆ. My son knows. ದಾವಾ ಸ್ವತ್ತಿನ ಖಾತೆಯಲ್ಲಿ ಮೂರನೇ ಪ್ರತಿವಾದ ಹೆಸರಿನಲ್ಲಿ ಬರುತ್ತದೆ ಎಂದು ಸರಿ. It means suitable property ಖಾತಾ is standing in the name of defendant number 3. They admitted it is true. Next, the cross-examination of PW1 dated page 12. ದಾವಾ ಸ್ವತ್ತು ಸದರಿ ಮುನಿಯಪ್ಪನ ಸ್ವತ್ತು ಎಂದರೆ ಸರಿಯಲ್ಲ. It is belongs to Muniyappa, they are not in it. ಸಾಕ್ಷಿ ಮುಂದುವರೆದು ನಂಜುಂಡಪ್ಪನವರ ಮತ್ತು ಇರುತ್ತದೆ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. It belongs to one Nanjundappa. ಸದರಿರವರ ದಾವಾ ಸ್ವತ್ತು.
Who is Nanjundappa?
Nanjundappa was the original owner of entire extent of land according to them.
Yes.
And ಸದರಿ ದಾವಾ ಸ್ವತ್ತಿನ ಮನೆಯಲ್ಲಿ ಎಷ್ಟು ವರ್ಷದ ಹಿಂದೆ ವಾಸವಿದ್ದರು ಎಂದು ನನಗೆ ಗೊತ್ತಿರುವುದಿಲ್ಲ. Who are in possession, how long this possession you are in possession andre we doesn't know ಹೇಳಿದ್ದಾರೆ. Yes, they are told me. ಸದರಿರವರು 2010-15 ದಾವರಿ ಸುತ್ತಿನಲ್ಲಿ ವಾಸವಿದ್ದರು ಎಂದರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ. I do not know till 2010 and 15 they are in possession. ದಾವಾ ಸುತ್ತನ್ನು ಮುನಿಯಪ್ಪ ಎರಡನೇ ಪ್ರತಿವಾದಿ ನಾಗರಾಜ್ ಅವರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ ಎಂದು ಸಾಕ್ಷಿಯು ಈ ಸುತ್ತು ಮಾಡಿಕೊಂಡು ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ ಎಂದು ನುಡಿಯುತ್ತಾರೆ. It means to say that Milord, suitable property Milord was belongs to Muniyappa, second defendant, has sold the property to the Nagaraj. That is the question. His answer is yes, he made a kata in respect of suitable property. Based on the e-kata, he sold the property. But once he himself admitted, second defendant is the owner of property. Second defendant made the transfer of kata. He sold to Nagaraj. Nagaraj in turn sold to the property third defendant.
Yes, Mr. Counsel, is it correct?
That is the
relevant para of the first appellant court, my lord.
No. Come to his grounds and the evidence that he is reading. That you have admitted that property stands as his name.
I produced the
and
Here LCR not before this court, my lord.
and I will produce.
I'm asking you to read what is there at page number 11.
Yes, my lord.
What he says is true.
Yes, my lord.
That you have accepted.
My lord. Second, in
Then
the
counsel
last
for the-
two lines, my lord.
Then counsel for the appellant shall produce shall place before this court translated copies of the evidence of PW1, how many, who are there PW1?
PW1 is the plaintiff.
And you are?
PW1.
PW1 and DW?
DW2.
And the relevant para.
Intermodal is extended till second. Yes.
Please, 3.
Next week,
Second is next week.
2 days more, we have to translation, more papers.
This is matter on 8th.
Please, 3. Serial number 5.
I appear for the appellant, my lord.
Yes, Mr.
For respondent number 1 in this case.
Yes, Mr. Mahesh.
Yes. Lord, it is appealed by the insurance company on question of liability, my lord. It's a case of injury.
Where is the finding with regard to liability?
Yes, my lord. Finding, my lord, your lordship gets it at paragraph
6.
Issue number 3, paragraph 6, my lord.
Please read.
Yeah. Second respondent has contended that the driver of the car was not holding valid DL at the time of the accident. RW1 has stated that the rider of the car was not holding DL to drive light motor vehicle. RW1 has also stated that the said driver had DL only in respect of two-wheelers. In support of her contention, Exhibit R1 is produced. RW2, who is the assistant RTO Udupi, has stated that the driver of the car was not holding DL to drive light motor vehicle. But in the cross-examination, he has also stated that they were not aware of the issuance of DL relating to light motor vehicle to the driver for
When
the
the
year.
accident had taken place?
Accident, my lord, is on 26/1/2012.
26/1/2012.
Yes.
And exhibit P3, exhibit R3 goes to show that RW3 is authorized to drive light motor vehicle with effect from 18/5.
Yes. Here, my lord, I would like to mention to your lordship, Ashok Kumar Hegde, my lord, who is the owner insured, was driving the vehicle admittedly. After service of notice from the tribunal, my lord, no statement was filed. And there was no compliance of my lord, section 134C of the FB Act.
Charge sheet is filed.
My lord, charge sheet is filed against my lord, the
Offense is registered under what sections? PCR is there? Give it. Please. Exhibit P1. P9. P9 and P1 both.
Exhibit P9, my lord, with the charge sheet.
Yes.
But now I would like to invite your lordship attention to my lord.
1 minute. Let me look at P9.
Yes.
Offenses are under section 279 and 338.
Yes. Here managed, my lord, with the police.
So basing on what you are saying.
Yes, my lord, I'll come to that, my lord. You are kindly see. Though he was served, my lord, with a court notice from the tribunal, though he appeared, no statement was filed. If really, my lord, what you had a driving license for LME, he could have, my lord, entered the, my lord, defense that he had a driving license for LME. He had not done so. Then, my lord, more particularly, there is no compliance of section 134C of the ME Act, which is mandatory, my lord, on the owner insured, my lord. That he has not done so. Then, after the evidence of, my lord, the insurance company, he get himself examined as RW3. My lord, I'll take your lordship through the, my lord, evidence of, my lord, RW1 and RW3. Officer of the insurance company, my lord, was examined, and there is no cross-examination, my lord, of this officer on issue of driving license by the insured responding number 1. Then, my lord, the RTO, my lord, was examined of Udupi. RW, my lord, 1 may kindly be looked into, that is the officer of this minute. Then RW2 is the Harish Kumar of RTO Udupi. There you have to kindly see the officer, my lord, of the RTO Udupi say that as per exhibit R1 which was produced, the insured, my lord, Ashok Kumar Hegde was not permitted to, my lord, or authorized to drive LMV. Until further, my lord, in the cross-examination is stated that his driving license lapsed in 2007. Then only in 2012, my lord, it was renewed. Date of accident, my lord, is 26/1/2012. And in the cross-examination, my lord, this officer of, my lord, RTO Udupi has said, if he has obtained driving license from any other RTO, then the RTO which issued originally has to be intimated about that. That is also not done. Then exhibit, my lord, the R3 may kindly be looked into.
Yes.
It doesn't bear the, my lord, the office seal of the, my lord, Shivamogga RTO, according to which, my lord, the insured that he obtained the license to drive LMV from Shivamogga. Exhibit, my lord, R3 does not bear the seal of the office of the RTO.
It is there. It is there on exhibit R3. Regional Transport Authority seal is there.
Right, what has been produced now, my lord, and moreover, you have to kindly see, he says, my lord, the owner was, I mean, examined. I don't have any difficulty in examining the concerned RTO from Shivamogga. But the main question is, if he had a license, what prevented him, my lord, when he was served with a notice of claim? He did not take any defense. And subsequently, my lord, this is the development made. And even exhibit R3, my lord, is not proved in accordance with law. RTO of Shivamogga, my lord, though he says he can examine, he has not taken any steps to examine the RTO Shivamogga. The genuinity of, my lord, exhibit R3 is in doubt and it is not proved as required under law. Therefore, my respectful submission, my lord, is that the reasoning of the tribunal on this issue, my lord, at para 6, my lord, issue, 2 lines from the bottom, my lord. RW3, the first respondent issued has stated that RTO Shimoga has issued DL to him. He has produced the extract of DL, which is marked as Exhibit R3. Exhibit R3 goes to show that RW3 is authorized to drive light motor vehicle non-transport with effect from 18/5/2007. There is nothing on record to show that. You will often kindly see, my lord, LME, my lord, private license, will be, my lord, for 20 years, not for 5 years. And there was a lapse, my lord, it was not renewed also. That is also come in the evidence of, my lord, the RTO was examined as RW3. With effect from 18/5/2007, there is nothing on record which goes to show that the DL issued by the RTO Shimoga has been revoked or suspended. Under these circumstances, it has to be presumed that DL was valid when the accident took place, and thereafter the contention that taken by the second respondent did not. It
Yes,
has to be presumed.
Agreed with the orders passed in MVC number 361 of 2012, so 3rd April 2013. The insurance company is before this court questioning the liability. It is stated that on 26/1/2012, at about 11:30 hours, when the claimant was walking on the side of the road, suddenly a car came from the Udupi side, and the driver, thinking of acting in a patient manner, came to the extreme wrong side of the road and dashed against the petitioner. As a result, he sustained grievous injuries, was shifted to the hospital and took treatment as inpatient, and he has spent amount towards the treatment. The court on the issue of liability has held that according to the insurance company, the driver of the car was not having a valid DL at the time of the accident. The RW1 has stated that the rider of the car was not holding DL to drive light motor vehicle. RW1 has also stated that the said driver had DL only in respect of two-wheeler. In support of their contention, Exhibit R1 is produced. RW2, who is the assistant RTO Udupi, has stated that the driver of the car was not holding DL to drive light motor vehicle. But in the cross-examination, he has also stated that they were not aware of the issuance of DL relating to light motor vehicle to the driver of the car by the other RTO office. RW3 first respondent has stated that RTO Shimoga has issued DL to him. He has produced the extract of DL, which is marked as Exhibit R3. Exhibit R3 goes to show that RW3 is authorized to drive light motor vehicle with effect from 18/5/2007. There is nothing on record which goes to show the DL issued by the RTO Shimoga has been revoked or suspended. Hence, the court has held that the driving license is valid when the accident has taken place and held that the insurance company is liable to pay the compensation. Then counsel appearing for the insurance company had drawn the attention of the court to Exhibit R3. Exhibit R3 is a driving license issued by the RTO Udupi. Yes, Mr. Ashok, look at this Exhibit R3, what it says. Those dates are confusing.
This is the driving license, what your lordship.
Huh?
Driving license
Huh.
is the driving license.
Driving license is from when to when?
Valid from when to when.
What I could understand from that is that license is granted in the year 2012. That is in the month of January.
31st January 2012 till 30th of January 2015. It is valid.
That is for heavy vehicle.
This is for motor. ನಿಮ್ದು ಯಾವ್ದು vehicle? Four-wheeler. It is for LMV minutes.
LMB.
LMV.
That's from January
31st January 2012 to
31st January
2012
to
30th of January 2015.
LMB is issued for 3 years.
3 years. 3 years. It depends on the age, minutes, how.
Accident has happened on 26/1. As on that day, no driving license. But the finding of the court is wrong. Anyway, you are the claimant.
Please, my lords.
Yes. What did you write? Exhibit R3, and basing on exhibit R3, he submits that the said exhibit R3 do not bear the seal of the RTO ODP. Further, it is submitted that both the owner and the driver are served in the appeal, served in the MVC, and they have not come forward and placed before the court the license, which clearly shows that as on the date of the accident, the driver of the car was not having a valid driving license. It is submitted that the court, without appreciating the same and contrary to the contents of RW3, has held that there is a valid driving license, which is factually incorrect. Next para. When counsel appearing for the claimant submits that the court had rightly considered the evidence and rightly granted the compensation and held that the insurance company is liable to pay the compensation. Next para. Having heard the counsels on either side, there is a material on record. It is a case of the insurance company that he is not having a driving license to drive the vehicle. Basing on exhibit R3, court has given a finding stating that the court says, as per exhibit R3, the driving license is from 18/5/2007. Where from it is there?
In fact, it is issued on 24/12/2002 for motor vehicle of the following description. The license to drive motor vehicle other than a transport vehicle is valid from 24/12/2002 to 23/12/2007. This, my lords, is with reference to the heavy goods vehicle. This what the renewal is done on 31/1/2012 to 31/2015 is for renewal of heavy goods vehicle. Your lordship will kindly see here.
That I have seen. Renewal is for the heavy vehicle.
Heavy vehicle.
For the LMB?
For LMB, my lord, there is no further endorsement. After 2007, I do not see, my lords, there is any endorsement.
You see, all LMB and all are struck off.
Yes. Because for renewal only this.
Before that, he was having a license for motor vehicle.
He was having for motorcycle with gear because there is a right mark, and also for motor vehicle other than the transport vehicle. Both he had.
LMB also he has.
Yes, from 2002 to 2007, 23/12/2007, and
So
thereafter there is renewal.
What did you write? Not able to hear. The court has given a finding that.
But even otherwise, it does not say, my lord, this license was.
Light motor vehicle with effect from 18/5/2007. There is nothing on record which goes to show that DL issued with RTO Shimoga has been revoked or suspended. This court has perused exhibit R3. Exhibit R3 mentions about the license in respect of the heavy motor vehicle between 31/2012 to 31/2015, and it shows that earlier
He was having a driving license between 2002 to 2007. Between 2002 to 2007. The finding of the court that, that there is no material to show whether whether the RTO has revoked or suspended the said finding is without any basis. And further, when there is an opportunity given to the owner and to the driver, when they have failed to place the driving license before the court, the considered opinion of this court, in those circumstances, in the light of Exhibit R3, the insurance company the principle of pay and recover will apply. The insurance company shall pay the compensation and record the same from the owner of the vehicle. The amount in deposit shall be transmitted. Next.
Amount in deposit to be, my lord? Amount in deposit
What
to
is
be.
that?
That amount in deposit to be returned to the insurance company.
I said that. I said so.
Please.
Yes.
Serial number 6, N.
On this case, NBC was remanded back to the MACT matter. In that time, liability fixed on 60-40 liability matter. And in the case of negligence.
Switch on the mic.
In the case of negligence and quantum, my lord. So on this appeal for preferring that income taken was MACT 60,000 per annum.
The tribunal has fixed the contributory negligence.
Not in this manner. Earlier round of litigation, my lord, it was remanded back to the tribunal to consider operation. Thereafter, tribunal has considered and fixed the liability on the insurance company. Now they are challenging the tribunal order on the two grounds. My lord, one is the tribunal has not awarded the contribution.
How much is the compensation granted?
4,11,000 is awarded.
How much?
4,11,000. Now, my lord, in this, my lord, in the accident has taken place on 25/11/2005, my lord. The tribunal has taken the income of the claimant, my lord, is 5,000. Though I have produced the income tax returns, my lord, in Exhibit P 91, my lord. That is, as I discussed, my lord, is senior, he said a little bit more is awarded, so it may be considered, my lord. That my lord, 4,500 or 4,000 it may be considered, and that had, my lord, in the
case of death.
No, my lord,
Injury
it is
may
an
be.
injury. It is in, my lord, in the
the
page
file.
number
Come to that.
chart, my lord. Page number 27, my lord.
No. Accident is on 25/11/2005.
5, my lord.
According to you, what is your income?
According to my lord, it is 7,000. I have
7,000?
7,000 rupees. I have
Court had taken 5,000.
5,000.
Disability?
Disability is taken 10%, my lord, though it is awarded considered 15%, but while calculating it is 10% is taken.
No appeal is filed by you.
No, my lord.
So that's the reason kindly consider the 4,000 income. It is
That's
in
why.
Page number
Pain and
27.
Suffering, how much is granted?
Pain and suffering is not noted, my lord, in the.
It's granted pain and suffering.
20,000 is awarded, my lord. It page number 27, my lord, in the.
You will not interfere with that. Then loss of future income.
1,35,000. That is
is
disability and
4,500. How much should be considered?
4,000, my lord.
4,000 into 12 into what is the multiplier?
15, my lord.
Correct?
Yes, my lord.
Disability 10%.
10%.
$72,000.
Into 1 lakh.
What about the?
1,08,000.
What is that?
It is on the head, my lord, in the loss of income under the head of the disability, my lord, in the first head, my lord, page number 27. The calculation, my lord.
It has
Disability.
come to 1,35,000, but it comes to now it comes to
Now,
72,000.
my lord, 6,000 it has considered and 60,000 taking into that, my lord, 60,000 into 50 into 10% disability, it is 1,35,000 it was awarded.
No,
Now it is come to 1,08,000, my lord.
no, 4,000
4,000
into 12 into 15
please, my lord.
into 10 divided by 100. It comes to 72,000.
Yes, my lord, please.
Medical bills?
It is correctly,
It's
1,90,000, 96,000 is.
Loss of amenities?
Loss of 30,000 is awarded.
On other grounds, you are not.
No, my
questioning.
lord, only that one part.
Loss of income during later period also will reduce by 2,000.
No, my lord, it is because he is in hospitalized, my lord, 43 days he is in the hospital. I have, since I have not filed the crop, my lord, in the enhancement, so I have restricted only to the income, so.
All
Please, ma'am.
conveyance, food, nourishment.
10,000 is awarded, my lord.
All together it is about
10,000,
10,
10,000,
20,000. How many days you are in hospital?
43 days, my lord, in the 43 days, my lord, inpatient. In the disability, my lord, they tribunal has admitted it is 15%, by calculating it is 10%, my lord.
It comes to 3,48,000.
Yes, my lord.
What about the contributory negligence? That you are not pressing.
Is not.
Agreed with the award passed in MSC number 373 of 2006. The insurance company is before this court questioning the quantum of compensation.
Yes, my lord.
Questioning the quantum of compensation. It is submitted by the legal counsel appearing for the insurance company that the accident had taken place in the year 2005 and the income is taken at 5,000 without there being any evidence on record. It is submitted that the compensation that is granted and that's of loss of income, loss of future income, basing on that 5,000 is on the higher side. Land counsel appearing to the respondent claimant submits that the court had granted a just and reasonable compensation. The considering the income at 5,000, the court had considered the compensation as per the table given below. Extract the table. This court having heard the counsel on either side peruse the material non-record. This accident of the year 2005 and the court had taken 5,000 as income. Considering the date of accident, this court is inclined to take the income at 4,000. That is 4,000 into 12 into 15 into 10 by 100 is 72,000. As far as the other heads are concerned, court has reasonably granted the compensation and this court finds no reason to interfere. Accordingly, the appeal of the insurance company is partly allowed, reducing the compensation from 4,11,000 to 3,48,000. The amount in deposit shall be transmitted to the trial court. Yes, next.
Much obliged, my lord.
Yes. Serial number 7. Ashok and Patil.
Appear for response. Respond, counsel, madam.
Yes, Mr. Kans, you're on liability?
I am on liability minutes, yes, ma'am.
On what ground?
It's on the ground that the driver did not have valid and effective driving license.
And what is the finding of the court on that?
Finding is that he had a LMV driving license, though it was not a transport vehicle, therefore, my lords, it is held on me now. But admittedly, the vehicle, my lords, is a light goods vehicle, my lords, weighing, my lords, below 7,500 kilograms. Mukund Devangan case would, my lords, still
Then
cover.
about quantum?
Quantum, my lords,
Quantum,
CS
my
filed,
lord.
my lords.
The case of death or injury?
Case of injury, my lord.
How
Date-
much is? How
Date
much
of
is?
accident, my lord, 20.
No, no, I'll ask, you can tell, so
Please.
that it'll be easy.
Please.
Which year is the accident?
My lord, 26/2/2012
26.
to 2012, my lord.
According to you, what is the income?
Income, my lord, 10 years boy, my lord. No income,
Yes,
my lord.
boy.
He was studying in 5th standard.
Hmm.
My lord, sustained fracture, my lord. Injuries.
How much is granted?
My lord, total compensation, my lord, 3,900.
3 lakh?
3,900.
3 lakh, 3,900.
My lord, fracture, my lord,
What is the
amputation.
disability?
Disability 75%, my lord, doctor says, my lord, amputation of below knee, right leg.
No, if that Mallikarjun's case is applied, how much it would be?
Mallikarjun case, my lord, it is not applied, my lord. This honorable court, my lord, on minimum wages is taken, my lord. This bench, my lord. This bench, I will send it, my lord, copy of the judgment. MFA, 4 years boy, my lord. Minimum wages taken, my lord. This bench judgment, my lord. MFA 4176 of 2017, my lord. Page number 9 onwards, my lord.
Kajal and Master Ayush is applied.
Yes. Ayush and Kajal case is followed, my lord. And
So-
amputation, my lord, same.
For 2012, what is
My lord, local chat, my lord, 2012, 7,000 income, notional income, my lord. 7,000 notional income.
That case, my lords, will not to. That case is, my lords, I am told, my lords, it has been challenged in Supreme Court. It has been challenged in the Supreme Court, my lords. Most of the cases where, my lords, this basing on this, my lords, it has been challenged in Supreme
What
Court.
happened?
But it is still pending, my lords.
So this also you challenge.
My lords, I would seek, my lord, this, my lords. I would submit this.
Uh-huh.
Your lordship may kindly, my lords, defer it by 2 weeks. My lord, they are moving this matter, my lords. In fact, I inquired with this matter. They are moving, my lord, this matter.
We'll have it on 15th. This is matter on 15th.
I appear for R2, your lordship.
For the appellant, my lord. This for, I have challenged the quantum of compensation and also the negligence, finding of negligence, my lord.
Yes.
The accident has taken place on 28/12/2012, my lord.
28.
28/12/2012.
Hmm.
The petitioner was riding a motorcycle, my lord, and Jeep bearing number KH50G59 was parked left side of the road and suddenly turned towards right side without giving any signal and dashed against the petitioner vehicle, my lord. As a result, the accident has taken place. So far as the contributory negligence is concerned, the finding of the court is at page number 15, para 17, my lord.
Yes.
According to the petitioner, when he was proceeding on a motorcycle at KG Bridge, a jeep came with high speed in rash and negligent manner and
Which
suddenly
paragraph?
took
Which paragraph?
para 17, my lord. Para 17, page 15. According to the petitioner, when he was proceeding on a motorcycle at KG Bridge, A jeep came with high speed in rash and negligent manner and suddenly took turn towards right side, as a result of which it dashed to the motorcycle. Hence, according to the petitioner, the respondent, being the owner and insurer of the vehicle, are liable to pay the compensation to the petitioner. But the respondent number 2 taken contention that the petitioner himself riding his motorcycle with high speed without following traffic rules, while overtaking the jeep, dashed to the jeep. Hence, the respondents are not liable to pay any compensation to the petitioner for his own negligence, and further, the petitioner is not having DL. But with respect to these aspects, the respondent number 2 not led any defense evidence to disprove the contentions of the petitioner. Further, in cross-examination of PW1, he has stated that he has lost DL, but with respect to that, he has not filed any complaint, and further admitted that he was given a statement to the police stating that 3 persons were proceeding on his motorcycle, and in the cross-examination admitted that he is having a knowledge of offense if 3 persons proceeding on the motorcycle. So when PW1 himself admits that 3 persons were proceeding on the motorcycle at the time of accident, moreover, he is also not having a DL, then naturally there is a negligence on the part of the petitioner also. Merely the respondent not led evidence, it is not a ground to disbelieve the version of respondent. The respondent elicited the same in cross-examination of PW1, then definitely the negligence of petitioner is to be taken into consideration. So when the petitioner himself is negligent, by,
I've seen.
yes, my lord, yes, my lord. Therefore, here there are decisions of our own High Court and as well as the Supreme Court decisions. The recent decision of the Supreme Court is 2020 ACJ 751, my lord. And also, if there is no DL, or even if there is they are riders with 2 billion riders, even then the presumption cannot be made as a negligence. Negligence presumption cannot be made against the claimants, my lord. That is a different offense. It can be collected the fine, my lord, for that. The Honorable Supreme Court, I have produced the decisions of the Honorable Supreme Court. 2014 ACJ 1012 is the full bench decision of the Supreme Court, my lord.
No, it all depends upon the facts of the case.
Yes, my lord. The same facts are involved in this case also. May I read that?
That I understood. Next, what is the next aspect?
Next is, my lord, is with regard to the quantum of compensation, my lord. Quantum of compensation, loss of amenities has not given, and the Honorable Tribunal has taken the income 6,000. 2012 is the accident. 7,000 ought to have been taken.
Page 15, your lordship.
This is a difficulty with this virtual hearing. Page number?
15. Towards pain and agony, 27,000. Towards inpatient, 1,500. Towards medical expenses, 30,000. Towards loss of income, 18,000. Total disabilities, 2,38,680.
What are the injuries?
The injuries to the right leg limb, your lordship, and the doctor has stated 39%
As per the
disability
wound
to the
certificate, the petitioner sustained abrasion of the left knee and fracture of both bones of the shaft of the left leg, which is grievous in nature.
kindly see the
Grant 40,000 towards pain and suffering.
judgment of the
Then how many days he was inpatient?
5 days, your lordship,
Where do you get that?
in Ramaya Hospital.
That the petitioner taken treatment as inpatient for 5 days. Entitled 5 days. Attendant.
39% is permanent disability of the left lower limb. And as per the doctor, 19% whole body.
Whole body 19%.
It is 5,000. What about medical expenses?
Medical expenditure bills have been produced 28,657 rupees.
Court has granted 30.
30.
Which year is the accident?
Accident in the year 2000.
What is the amount, income as per the chart?
6,000 per.
7,000, my lord.
You said 2000?
12.
2012.
Yes, my lord.
It is 7,000.
Yes, my lord. But the court has taken 6,000.
Only for a period of 3 months, Your Lordship. It's a skilled labor.
That is only granted. So taking the income of 7,000 into, as per the doctor, what is the disability?
39%.
Hmm.
For the limb. For whole body, 19%.
Court has taken
13%, my lord.
13.
He is a carpenter, my lord.
rightly taken 13%.
30%.
7,000 into 12 into what is the multiplier?
Multiplier is 17, my lord. Age is 28 years.
It comes to 1 lakh. It is
Loss of amenities has not granted, my lord. And future medical expenditure has not granted.
oh, disability when the court had taken how much? 6,000?
6,000 and 13%.
Yes, 13%. It has come to 2,38,680, but it is coming to 1,85,640 now.
In the award also, the petitioner is entitled for compensation of rupees 3,15,180 rupees, out of which he is entitled for the compensation to the extent of 80%. Example,
There is
2,50,000
something wrong with the calculation.
without valid license and triple riding.
Huh?
Without valid license, the petitioner is without
Yes,
valid.
Mr.
Without, he is not having a.
1 minute. Yes. Counsel for the petitioner.
Yes, my
7,000
lord.
7,000 into 12 into 17 into 13 by 100 is how much? There is something wrong with the calculation done by the trial court. Now you will
Yes,
be,
ma'am.
now after enhancement, it will come to 1,85,000 and the court had granted 2,38,680. That calculation is wrong.
Yes, my lord. Yes, my lord. And future medical expenditure, doctor
How
has
you
taken.
clarify this? Now, What is granted by the court is 2,38,680.
Yes.
Now this court will be granting 1,85,000.
Total compensation.
So you're not even having a calculator.
My lord, according to me,
7,000 into
but
12 into 17 into 13 by 100, how much it is?
because he is a carpenter, so the loss of earning capacity may kindly be considered to some higher amount, my lord.
Mr. Latur, first of all,
Yes,
you
my lord.
clarify the court's query. On
Yes,
what
my lord.
basis the court had granted towards disability 2,38,680?
No, no, my lord, I have not verified it and
Tomorrow,
it has,
doctor, do it, look at it.
yes, my lord.
In this. Tomorrow, not tomorrow, day after, 4:30. Yes.
Serial number 9.
Who appeals to the respondent?
My lord, if your lordship agrees with me, other side is required, my lord. It's on negligence, my lord. What the case of the corporation, my lord, is that the bus, my lord, the accident in question occurred at 13:20 hours at Ramurthy, my lord. To show that, my lord, the bus did not fly at that point of time, my lord, I have examined two witnesses. Firstly, my lord, the driver denies that the bus went in that line, in that route at that point of time. And it was, my lord, in other place called Devasandra at that particular point of time. So the evidence has been led, my lord, by two persons. That is one traffic controller. Along with the sheet, my lord, we have for the KSRTC buses, we have a form, my lord, form number 4, the schedule on which they have to, my lord, fly the bus. And this has been disbelieved by the MACT on the ground that FIR has been filed, charge sheet has been filed against the driver of the bus and it's not questioned. My lord, the court has to see, my lord, now ultimately if he's acquitted, my lord, that cannot be the basis. The case of the corporation, my lord, should the MACT should have examined on the basis of the evidence laid before the court. I'll take your lordship to that particular portion, my lord.
No, we'll have it tomorrow. Anyhow, this is final hearing matter. It can be third list tomorrow. List is matter tomorrow as part heard. No representation for the respondent, for the learned counsel, for the appellant. Yes, next.
10.
One appeal filed by the insurance. Given a copy, happy to file a one appeal filed by the insurance.
Insurance company challenging an appeal, granting compensation to the extent of 40,000.
File your wakalat in their appeal.
I am the claimant, madam.
That's what I'm saying. You have filed wakalat in 10.2 also.
Each member next week I'll file a wakalat, madam.
2015 will not wait for any of these reasons. Argue if you want to file wakalat, file at a later point of time. Because if they have not given you wakalat, it is served, we will already notice is held sufficient. They have served, we will proceed with it. 2015 will not adjourn on any of the grounds. Yes, if you want maximum, if you want on second, we'll give it on second.
Please.
This is matter finally on second. No further time will be granted. Yes, next.
Serial number 11. Suresh Latur.
Where is
Yes,
Pradeep?
my lord. Here also I'm enhancement of compensation. I'm claiming for enhancement of compensation, my lord.
Ready?
I'm ready. Let him address here.
You are here, tell the court what is the...
No, but I don't have any papers, my lord. Basing on his argument, I will address that. Or otherwise, it may be have it on tomorrow. I will.
Tomorrow better.
Please.
Tomorrow.
Because they have not brought the file. That's...
Tomorrow. With the request of learned counsel for the respondent. Yes, what about 12?
This is the case of injury, my lord. The The date of accident is on 23/11/2011. My profession is a tailor, and the court has taken the salary as 4,000 rupees. Notional income has taken as 5,000 per month only, and he was inpatient for more than 36 days. The court has granted 1,92,400 on various aids, pain and suffering 30,000, conveyance charges 5,000, medical expenses 5,000, loss of income during the treatment 30,000, loss of earning capacity. The doctor stated 33% to the particular limb and whole body 18% disability.
34 to this 42. It is from MFA 2018 till 42 for all these cases. Two cases in a day. Two cases in a day. We start giving dates in the month of April. From April 21st, start giving dates for this from 34. Two matters one day, all these matters. And with this from 34, above 34 will continue in the list. Yes. When is the accident?
Accident is on 23/11/2011.
23/11.
2011.
According
Yes.
to you, what is the income?
5,000 rupees. 7,000.
7,000 according to you. And how much the court had taken?
Notional income 5,000. 5,000.
As per the table, it should be 6,500.
33% disability to the particular limb and to the whole body 18%.
Okay.
You are on what ground?
Permit is not there. On the date of accident, there was no permit.
Permit. Where is the table?
The table in page number, para 17 of the judgment. Fracture of neck of femur.
One fracture.
Please.
Fracture of neck of femur and
How many days?
fracture of shaft of femur. He was 36 days inpatient. Thrice he was admitted.
Where from you get that? From the order?
No, it is not there.
In para 16 of the judgment.
Read.
Para 12 last, the petitioner has produced the discharge summaries of the MS Ramaya Hospital exhibit P7 P8, which shows that the petitioner was admitted to the said hospital on 23/11/2011 and discharged on 9/12/2011 and again on 10/3/2012 and discharged.
How many days? 30?
That year 28, again for third time he has admitted for another 10 days.
38 days.
That additional document I have produced.
Yes, produce the additional document before this court now.
No, as per it is 28 days.
28 days.
Medical expenses.
Medical expenses.
No, 5,000 it is granted that no document was placed.
Court had granted for 6 months loss of income.
Yes,
please.
So 6,500 you are taking to 6,500 into 6, 29,000. Then loss of earning capacity, loss of future earning.
Court has taken 12%.
Disability according to the doctor?
33% to the particular
30%
limb
to the
and
limb,
18%. 18% to the whole body.
1/3 it is
Court had taken
12% it is taken.
Court had taken how much?
12%.
It is 30 or 30?
33% to the limb.
Court had taken 12%.
12%.
Amenity was not granted.
One minute. What is the multiplier?
Multiplier is
17.
13. 17 multiplier.
17 multiplier.
30 years on the date.
It comes to 1,59,120.
Please.
Loss of amenities, 30,000.
Please.
It comes to 3,16,120. It is, what is granted is 1,92,400. Now please come to the liability issue.
Please. Para 18 of the judgment.
Read.
Respondent 1 is the insurer and the respondent number 2 is the RC1 of the said motor vehicle. R1 insurance company has taken the contention at the time of there was no permit for the said maxi cab. Therefore, company is not liable to pay petition. On the document produced by the insurance company, it is disclosed that the accident was on 23/11/2011. The permit to maxi cab was up to 22/11/2001. Therefore, it is good on 23/11/21, no valid permit to the vehicle, but merely on that ground, company cannot avoid its liability to make payment compensation.
Owner of the vehicle is served.
Pardon?
Owner of the vehicle.
Please.
Please come.
Interest is 8% is granted.
Agreed with the orders passed in MAC number 81 of 2012. Dated 2nd April 2016, both the insurance company as well as claimant are before this court. Insurance company's appeal is MFA number 3661 of 2016 and the claimant's appeal is MFA number 50650 of 2016. The claim petition is filed seeking compensation of an amount of rupees 5 lakhs for the injuries sustained by the claimant in the road traffic accident on 23/11/2011. According to the claimant, he had sustained abrasion over the left elbow and the fractured neck of the femur with inspirational fracture shaft of the femur left side. The doctor had deposed that the claimant had sustained 33% disability to the whole body and
Particular limb.
33% to the limb.
33%.
33% to the limb and whole
18% to the
18% to the whole body. According to the claimant, is earning an amount of rupees 7,000 per month, and court had taken 5,000 per month, 5,000 as income per month, and granted the compensation as per the table given below at page number, para number 17. When it comes to the liability, it is a case of the insurance company that the vehicle was not having a valid permit as on the date of the accident, and as such, the insurance company is not liable to pay the compensation. The court had observed that on perusal of the documents produced by the insurance company, it discloses that the accident took place on 23/11/2011, and the permit of the said maxi cab was up to 22/11/2011. Therefore, on 22/11/2011, no valid permit is there to the said vehicle, but merely on the ground on that ground, insurance company cannot avoid its liability to make payment of compensation. And it is also not the case of the company that there was no valid permit. And the insurance policy was enforced. It is submitted that accordingly the court has held that the insurance company and as well as the insurer and the insured are jointly and severally liable to pay the compensation. Next, land counsel appearing for the claimant submits that the compensation that is awarded by the court is not a reasonable compensation. Court had not taken the income at
5,000.
5,000, when it is treated that it is, his income is 7,000. He submits that on all counts, the amount has to be enhanced. When counsel appearing for the insurance company submits that when there is a fundamental breach of the terms and conditions of the policy, the court ought to have granted, to have applied the principle of pay and recover. Whereas in this case, though as on the date of the accident, there is no valid permit, still the court had fastened the liability on the insurance company. Next para, having heard the counsels on either side, peruse the material on record. First, coming to the aspect of liability, accident had
Covered by
taken place.
Amrutpal Singh.
Huh?
Amrutpal Singh case.
Huh?
Covered by Amrutpal Singh case.
Pay and recover.
Pay and recover.
When it comes to the liability, on 23/11/2011, the accident had taken place, and the permit was up to 22/11/2011. It is hence it discloses that as on the date of the accident, there is no permit. In the light of the law laid down by the Honorable Apex Court in Rani versus so and so, the insurance, it amounts to breach of the terms and conditions of the policy, and the principle of pay and recover applies. As such, insurance company shall pay and recover from the owner of the vehicle. Next, coming to the compensation, the claimant had sustained one fracture, is entitled for an amount of rupees 40,000. He was in hospital for 28 days. Towards conveyance, transport, and nourishment, is entitled for 28,000. Towards medical expenses, basing on evidence, court had granted
5,000.
5,000.
5,000.
Court had granted 5,000. Then it will be 3,01,120. No, 3 lakh. 11,000. Had granted 5,000, which is reasonable, and no interference is called for. Loss of income during the later period. The court had considered 5,000 and granted for 6,000, and this court is considering the salary at 6,500 as the accident has happened in the year 2011, and as per the chart, court is taking 6,500 into 5 is 39,000. Then coming to the loss of future earning, 6,500 into 12 into 17 into 12 by 100 is 1,59,120. Then considering the disability of 12%, the loss of amenities granted at 30,000. The light of the law laid down in make law so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,11,120. Accordingly, the appeal of the claimant is allowed. No, in the insurance company's counsel submission, the rate of interest is granted at 8% instead of 6%. Accordingly, the appeal of the claimant is partly allowed, enhancing the compensation from 1,92,400 to 3,11,120. The appeal of the appeal of the insurance company is partly allowed by reducing the rate of interest from 6% to 8% to 6%. Amount in deposit shall be transferred to the trial court.
Pay and recover.
And the amount shall be paid by the insurance company and shall recover the same from the owner of the vehicle.
Much obliged.
The second list stop. No, from 13 to 34, they will come in.
Serial number 20, Malad. Serial number 20 in third list will be taken up on first, Malad. Tomorrow and day after I am not in station.
Serial number?
20. 20 and 20.1.
20 and 20.1 on second.
Please.
Serial number 30, Malad. This has to be tagged along with MFA 675 of 2018, which is pending before the division bench.
A memo is filed.
The memo Allah. What has happened? The insurance company has challenged the award passed by the tribunal awarding my lord, revenue, loss of revenue and damages. In fact, in similar type of appeal, my lord, on the basis they have challenged.
What is to be done now?
Now it has to be tagged along with.
For that you should file a memo. Something you have to file
I
saying
will file,
that,
ma'am, no.
please file memo. It is submitted that a memo is filed stating that the connected, the appeal filed by the insurance company, that is MFA number.
So that there are a lot of matters.
675 of
along with
2018.
675, and it has been referred to the larger full division bench. Because the
Fully like
issue
it is
was, there was divergent findings of this.
Then we'll adjourn this matter for some time, then we'll see. List this matter.
Because there is a direction from the division bench, all these type of matter has to be tagged along with.
It is submitted, the connected matter is, the insurance company has preferred appeal, as filed MFA number so and so, and the connected matters are pending before the division bench. And there is an order by the division bench to place all the matters before the.
That is before that. I have produced
To tag all the matters to the pending matter before the division bench. Accordingly, the registry is directed to place this matter, to tag this matter along with so and so. Yes.
On submission, please. Similar 13. Date, madam. Knowledge.
No, no, all this, this court will hear the final hearing matters till 17. So for all the, from 34 till the last one, the dates will be given. In any of either in MSA or in MFA, court will hear only the final hearing matters till 2017. So
Date ಕೊಡ್ತಾರೆ.
from 34, right from 20, no, it's from June, in the month of June, every day, give two matters, two matters in the month.
2015 melad 28 serial 2015 matter early
That will
date.
be heard. That will be heard. It will come tomorrow in second list.
Please,
Till 34, all the matters will come tomorrow in second list.
please.
Serial number 40, it has been coming up 3 times in this month, the final hearing. I need hear this matter next week or serial number 40 only.
No, there are so many old matters. What is the priority to these matters?
Your Honor, my lord, this, the administration of the estate has to take place because all the properties are in outside
For this
Karnataka.
41, 40, 41 and 39, 40, 41, list these matters on 23rd of April. 1 minute. Yes.
May 42 also be listed on the same day.
42 is what? That also I said.
My lord.
39, 40, 41, 42.
Serial number, my lord, serial number 24 list 3. Can we have it on second or second or third?
20?
24 list 3. Kindly have it on second or third.
Wait, tomorrow there is any difficulty? Second.
Serial number 16, my lord. List 3. Respond counsel.
Serial number?
16, my lord. 16. List 3. The respond counsel is Seychelles out of station, my lord. Kindly have it to 1st April, my lord.
Yes, 16 also. 2nd April.
Please.
My lords, list number 3, serial number 13, my lords, kindly have it tomorrow.
It will come. All the matters will come tomorrow till 34. How many are the disposals? Hmm?
ಸರ್ ನಾನು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಚೇಂಜ್ ಮಾಡಬೇಕು.
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಮೇಡಮ್.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 9 ಡೇಟ್ ಹೋಯ್ತಾ ಮ್ಯಾಮ್ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಕೊಟ್ರಾ?
ಲಿಸ್ಟ್ 2 ನಾ?
ಹಾ ಸೀರಿಯಲ್ ನಂಬರ್ 9.
ನಾಳೆ ಸರ್ ನಾಳೆ ಬರುತ್ತೆ.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು ಮೇಡಮ್.
37 ಏನ್ ಡೇಟ್ ಕೊಟ್ರಿ? ಲಿಸ್ಟ್ 3.
ಹಾ
ಜೂನ್ ಅಲ್ಲಿ ಕೊಡ್
37 ಏನ್ ಡೇಟ್ ಕೊಟ್ರಿ? ಲಿಸ್ಟ್ 3.